Sir, court officer. Sir, court officer.
Listen.
Sir, page-wise adjournment ಇದೆಯಾ sir?
ಇದೆ sir.
Thank you.
ಇದೆ.
Thank you, sir.
Okay.
ಆಶೀಶಿದಾರ್ ಅವರು ಕಾಲ್ ಮಾಡಿ ಸರ್. ಯೂನಿವರ್ಸಿಟಿ ಚಿತ್ರದುರ್ಗ ಪೂಜಾ ಕೇಸ್ ಅಂತ ಹೇಳಿ ಪೂಜಾ ಏನೇನ್ ಮಾಡ್ಬೇಕು ಇನ್ನ ಬರ್ತದೆ ದುಷ್ಯವ್ರ ಮುಂದೆ ಇದಾಗಿತ್ತು.
Court officer. Court officer. Court officer.
ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಅಲ್ಲಿ ಏನೇನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ನೋಡಿ. ಹೌದೌದು, ಈಗ ನಾನು ವಕಾಲತ್ ಹಾಕ್ಬೇಕಾದಲ್ಲ, ಅವ್ರು ಇಲ್ಲಲ್ಲ. ಈಸ್ ನೋ ಮೋರ್. ಕೇಶವ ಪ್ರಶಾಂತ್ ಇಸ್ ನೋ ಮೋರ್. ಹೇಳಿ.
ಸೆವೆನ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
ಅದೇ ಏನೇನದು ಅಂತ.
ಇಂಡೆಕ್ಸ್, ಅವಾರ್ಡ್ ಅಮೌಂಟ್,
ಎರಡಾದ್ರೆ ಹೇಳ್ಬೋದು ಸರ್.
ಲ್ಯಾಂಗ್ವೇಜ್ ಕರೆಕ್ಟ್ಲಿ ಏನೇನೋ ಇದೆ ಸರ್. ವಕಾಲತ್ತಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2, 4 ನೇಮ್ ಕರೆಕ್ಟ್ಲಿ, ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4, 5 ಏಜ್ ಕರೆಕ್ಟ್ಲಿ.
ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಇದ್ ಮಾಡ್ತೀನಿ ಬಿಡಿ.
ಇದು ನೀವು ಹಾಕ್ತೀರಾ ಸರ್ ವಕಾಲತ್ ಇದ್ರಲ್ಲಿ?
ನಾನು ಹಾಕ್ತೀನಿ, ಈಗ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀನಿ.
ಮಹೇಶ್ವರ ತೋರ್ಸೋದ್ ಬೇಡವಾ?
ಬೇಡ ಬೇಡ, ಏನಿಲ್ಲ, ಬೇಡ. ಆತರ ಏನ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಯಾರಿಗೂ ಅವರು.
ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಆತರ ಇದೆ, ಕೊಡ್ತಾ ಇದೀವಿ.
ಇಲ್ಲ, ಬಟ್ ಹಂಗಿಲ್ಲಲ್ಲ, ಅವ್ರು ಯಾವ್ದು ಇದ್ದೇ ಇಲ್ಲ. ಸರಿ, ಈಗ ನಾನು ಇದ್ ಮಾಡ್ತೀನಿ, ನಾನು ಹಾಕ್ತೀನಿ. Your name.
driver name, like
Lordship, this matter is, for the KPID and the competent authority is moving for an attachment. So that request my Lordship to kindly tomorrow, my
No,
Lordship.
what is that matter?
Matter is that special competent authority is moving in a process of attachment.
No, which authority?
KPID, my Lordship.
KP,
Yes, my Lordship.
yes, Monday.
Monday, yes.
Your Lordship may kindly recollect that the vacation matter, the interim order was granted by the bench.
Yes.
There's some the correction is to be made in that interim order. We have filed an application for correction of that model.
That, what is that correction?
That measuring of 2 acres 7 guntas, that is, it should be not 8 acres 19 guntas.
Yes, you placed before that. It has division bench has to be constituted.
Allah, I'm saying those.
Single judge the division bench.
Division bench will be.
Bench has to be constituted. Allah, correction.
Allah, correction, the application is filed not.
No, that
Instructions is issued not that will be registered there.
no, that only that correction in that extent. That we can done it in that chamber itself. Let we'll see that. Permission.
8 acres, not 17 guntas is used to be done. It
Instead
has
of,
been typed that not 2 acres 7 guntas.
yes, that we'll see.
That is all.
Right, MFA, both 3-5 along with 2 connected matter. 2020. That there, he also pending notice also issued to the respondent. That matter is pertaining to enemy property of act. Saying that the residents are the residents of Mangalore. But they stated that they are not Indian, they are Pakistan. They are living there since 1940s, 1932 on. But for that, there is an order by the custodian of enemy property of India. By the appeal, as per the provision of the enemy property act, that is pending. Working day on 13th, the notice dated 11, they pasted on the wall of the house of the appellant. So that's why there is urgency.
What is that matter? What is the suit? You have filed in a suit.
Not suit. That property, actually, case is there.
Under which provision you have filed in a
Appeal under section 11 of the Enemy Property Act. Because that who are residing in India, if they during the partition period, India and
Monday.
Yes, Monday. They pasted on last working day. I did not know it. I filed IA also.
Same matter,
Same 3 connected. Yes,
Monday.
Page number 1, page number 1, serial number 1 to 8.
Serial number 4, which submitted to maybe here is not
That finally 2 weeks time is granted to comply that obstacle. 1 to 8. You do it, I granted 2 weeks time.
My lord, one submission, my lord. My lord, one
No,
submission.
serial number.
Serial number 5, my lord.
Let us see first it is an adjournment. We'll see. Yes.
Page number 1, page number 1, serial number 1 to 8.
My lord, serial number 5, my lord.
Want adjournment?
Yes, in this case, my name may be shown, but I'm going to file Wakalata since Keshav
Yes,
Prasad.
no, this is adjournment. Wait. Yes.
Page number 2, serial number
6. Serial number 6.
Hmm.
Rest time 2 weeks.
Surendra Kumar N.
2 weeks time is granted at the request of the appellant to comply after subjection.
Page number 2, serial number 9 to 19. Page number
No, sorry, Mara. I have granted earlier. Why I have granted earlier? Yes, yes.
Page number 3, serial number 20 to 23. Page number 4, serial number 24 to 29.
Serial number 28.
Only 1 week to be.
28, Gita Devi MP.
At the request of counsel for the appellant, finally, weeks time is granted to comply that absence.
Serial number 26, my lord.
Hmm.
And may be granted, my lord.
At the request of appellant, finally, weeks time is granted.
Pleasure.
Yes.
Page number 5, serial number 30 to 36. Page number 6, serial number 37 to 44.
Serial number 39 to 43.
Hmm.
The council is filing a memo, my lord, saying that, my lord, they have to go before division bench, my lord, valuation. All matters has to go before division.
What is that value?
Valuation, my lord, given memo that they are.
4 lakhs. ಅದರಲ್ಲಿ ಯಾವುದೇ objection ಅದು ಇದೆ. Correct counsel for the appellant has filed an memo.
Cross objective.
Where is that original appeal? ಯಾವ್ದು ಕ್ರಾಸ್ ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಿ? Wait when the matter is.
Appeal number, MFA number,
20, MFA 23 of 2022 is pending before where?
division bench.
Is it division bench? Yes, learned counsel for the appellant has filed a memo. Cross objector has filed a memo stating that the value of the appeal is more than 15 lakhs. Requested for post this matter before the division bench having in a roster. This is directed to post this matter before the division bench having in a roster.
My lord, serial number 44.
Yes.
I represent second respondent. The 3 applications filed by the appellant legal has in that matter. I want 2 weeks time for filing objection.
You are for respondent.
Last occasion I have received copies.
Yes, at the request of counsel for the respondent. Leave this matter of 2 weeks.
Much.
Page number 7, serial number 45 to 54. Page number 8, serial number 55 to 60.
That 56, madam. 56, P. Raju wants.
56, sir. Yes, 56 at the request of counsel for the appellant. Leave this matter next week.
Serial number 54.
Hmm.
I have obtained the 2 documents. That the.
No, it is for vacating. You have informed other side.
In fact, I filed the pleading application that. There
No,
vendors
I
have-
will inform
vendors-
for taking in adjournment.
I will inform that.
No, you inform and come when this is
My
restoring.
lord, serial number 58, I am for the respondent number 1. On that side, my lord can actually matter for you.
Serial number,
58.
you are appearing, you are appearing for that caveat.
Yes.
Yes, I will inform.
Yes.
Yes, at the request of counsel for the caveat or respondent. Leave this matter next week.
Page number 9, serial number 61 to 64.
That 63, madam.
63, yes.
63, ಮಾತಾಡಾಗಿತ್ತು.
Yes, yes, yes. Leave this matter on Wednesday.
ಇಲ್ಲ ನಾವು ಊರಲ್ಲಿ after 10th any date
Leave this matter on
15 madam.
15. Yes.
Okay, so 16 madam. I'm for appellant.
Serial number
16.
60.
Please.
Hmm.
Next week in a date.
So, after 58,
I appeal for the appellant person.
Yes, you are appearing for
Appellant.
ಅಲ್ಲ 2ರಲ್ಲಿ ಅವರು ಅಪೇರ್ ಆಗ್ತಾರೆ 2ರಲ್ಲಿ ನಾವು ಆಗ್ತೇವೆ.
connected matters idava.
Connected matters.
Yes, when do you want?
Next week any date my lord.
Yes.
Monday ಆಗ್ತದೆ.
At the request of counsel for the appellant. Please this matter next week.
ಆಮೇಲೆ interim order may be extended.
Interim order granted earlier is extended till next date of hearing.
Date ನಲ್ಲಿ give me.
Bharat next week. Yes.
page number 10, serial number 65.
My lords, I appear for the appellants in serial number 65. We had filed our memo for withdrawal of appeal, my lords, as the appeal itself has become infructuous. So the
Learned
same may
counsel
kindly
for
be
the
recorded as
Yes, learned counsel for the appellant has filed a memo seeking leave of this court to withdraw this petition on the ground that suit dispose agidya.
no,
Why?
my lords. Pardon, my lords.
Yes, matter was been settled out of court. Memo is taken on record. The above appeal is dismissed as withdrawn. Yes.
Cell number 17, my lord.
Grateful, my lords.
17.
Compliance element. Office objection compliance element.
Hmm.
Yeah, it's out of station, my lord. That's 2 weeks time.
17 weeks time is 2 weeks time is granted at the request of the appellant, counsel for the appellant to comply.
And 22 as well, my lordship. ಎರಡು cases.
22 what?
Same, sir. Non-obstruction, non-compliance.
No, 22 it is not yours, Mr. Janathan ji, wait when the matter is just.
Serial number 2, my lord.
Wait, Mr. Wait.
Serial number 25, my lord, I am filing a memo to withdraw them.
25. Senate counsel for the appellant has filed a memo of this court to withdraw this appeal. Memo is taken on record. The above appeal is dismissed as withdrawn.
Serial number 2, my lords. Raise 2 days time to comply the.
Wait, Mr. We'll call the list.
This is number 1 for orders regarding non-compliance of compensation, second time matter, serial number 1.
Your lordship, insurance company, I have already complied all the objections. Yesterday, they raised another objection that I have not served a copy upon them. Since they had filed a caveat subsequently, but by WhatsApp, I have sent a copy and I'm given the physical copy also to them, your lordship. There is no nexus. There is no nexus between the death and the injuries of the deceased who died after 1 year, 10 months of the alleged accident. And the injuries were also not in any way connected or apprehending the death
Is
of
there
the...
any delay? Delay?
No, no delay, Lordship.
Yes.
There is an attachment tomorrow. They
Yes,
have moved.
issue notice. They have. I 50% deposit.
50% I'll deposit it for dishonorable.
Coming to withdraw the
ಅಲ್ಲ ಸ್ವಾಮಿ, we have challenged that ಅವ್ರಿಗೆ ಇಂಜುರಿ ಆಗಿದ್ದು ಜಾಗೆ, ಶೋಲ್ಡರ್ಗೆ, ಫುಟ್ಗೆ. Our treatment records ಇಲ್ಲ, post mortem report ಇಲ್ಲ, even the charge sheet is also under section 279 and 338. I have requested them to produce at least the treatment records to show the connectivity between the death and the injuries.
No, you are disputing that
Yes.
he has suffered an injury in that accident.
Yes, your ಅಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಅವ್ರಿಗೆ ಇಂಜುರೀಸ್ ಆಗಿದ್ದೇ ಬೇರೆ ರೀತಿಯಿಂದ ಇಂಜುರೀಸ್ ಆಗದ 1 ವರ್ಷ 10 ತಿಂಗಳ ನಂತರ he died. So there is no connectivity between nexus between the death and the injuries.
No, that are you disputing that he has suffered an injury in the road accident by using your vehicle? There is no dispute. No,
Yeah.
ultimately, even if it is held that death is not due to that accidental injury, but he has suffered an injury in that
Yes, Your
accident. Some extent he is entitled for the compensation.
Yes, sir, but not the entire 50% is by compensation. That's all.
But I am just asking that you are denying that entire involvement of the accident, or there is he has suffered an injury in that accident.
He has suffered an injury, but there is no death. I mean, nexus that's all we have challenged.
Yes.
Yes, sir.
Okay. You are taking notice to whom, madam?
To all his claimants that are appearing only to respond number 9, Your Lordship. Up to respond number 8, they are represented by the council appearing for the caveators.
You are taking notice to whom, madam? How many claimants are there, madam? There are
Totally 9 are there, Your Lordship. 1 to 8 are the claimants. 9 is the owner of that vehicle, insured
Yes.
offending car.
You will take notice for 1 to 8.
1 to 8.
Yes. Suresh M. Latho. You have to take to appear for respondent number 1 to 8. Issue emergent notice to respondent number 9. Day of judgment and degree dated 28 June 2023, passed by 10th additional small cause judge MEACT Bangalore in MEC 4799 of 2018, subject to condition appellant has to deposit 50% of the award amount before the tribunal. The claimants are permitted to withdraw 25% of the amount which is deposited.
Actually award ಆಗಿದ್ದು 14 lakhs. 14 lakhs 71,000. 50% of which will be more than 7.5 lakh. Inclusive interest, it goes even up to 8 lakhs. ಅವ್ರಿಗೆ ಆಗಿರೋದು simple injuries plus 2 fractures ಇದೆ. So even 4 lakhs also will be more ಅಂತ ಅದಕ್ಕೋಸ್ಕರ.
Irli. Yes.
If he's found entitled, Your Lordship,
3 lakhs.
I'll be...
The claimants are permitted to withdraw 3 lakhs rupees. The tribunal is directed to release 3 lakhs after depositing that amount by the appellant in favor of the claimants after due verification. Within 4 weeks from date of today to deposit.
Yes, Your Lordship.
Weeks time is granted to complete the task. ಅದರಲ್ಲಿ serial number 5 ಅಲ್ಲಿ office is directed to delete the name of H.N. Keshav Prashant to the name of D. Vijay Kumar. ಅಲ್ಲ ಅದು ಎಲ್ಲ yes D. Vijay Kumar ಅದೊಂದು ಮಾಡ್ಬಿಟ್ಟು 2 weeks time granted to complete the task.
Please, my lord.
Yes. Yes, council submission regarding non-arriving the R1 before so and so. Maxine was none appears. It is matter next week. Yes, 2 weeks time. 2 weeks time is granted to comply the task. 2 weeks time is granted to comply the task. Yes, none appear. Finally, 2 weeks time is granted to comply the top subjection.
Serial number 11, Vishwarappa VK for appellant.
4 weeks time may be granted, Your Worship.
Yes, at the request of counsel for the appellant. Finally, 4 weeks time is granted to comply the top subjection.
Serial number 12, Vyasa VK.
Here, finally, 2 weeks time is granted to comply the top subjection.
Serial number 13, Rajaram P.
Lords, 2 weeks time.
At the request of counsel for the appellant, 2 weeks time is granted to comply the top subjection.
Serial number 14, Allah Prakash for appellant. Enna Jagadishwara.
Yes, none appear. Weeks time is granted to comply the top subjection.
Serial number 15, Raghavendra HS for appellant. Serial number 15, Raghavendra.
Regarding that. Appear with this matter next week.
Serial number 16, Kamala DK.
None appear. Finally, 2 weeks to comply of subjection.
Serial number 17, Again, serial number 18, PS Venkata Subbarao.
Yes, at the request of counsel for the appellant, 2 weeks time is granted to comply of subjection.
Serial number 20, Vijay Kumar. Serial number 20.
The request of counsel for the appellant, 2 weeks time is granted to comply of subjection.
Serial number 20, Chetan Kumar H.
Lord, I care for the appellant.
Note of translating with regarding to the R1 and before the trial court has not arrived as what is in the setting. Right,
My lord, the petition was dismissed as against R1 and R2. They were not necessary parties to the reference application.
R1 and R2.
That is found at page number 35.
5.
Petition against R1 and R2 is dismissed. There are R1 is the land acquisition officer assistant to Mr. Chitradurga, and the R2
Yes.
is executive engineer Karnataka Water Supply. And they both are not.
Submission of learned counsel for the appellant with respect of office objection is accepted. Office objection is overruled. Yes, what is this matter?
My lord, with regard to the condemnation of deal application, I need to make certain written submissions. Because the office has not taken into consideration the COVID delay, which has been granted by the Honorable Supreme Court.
No, there is a delay now.
Delay is there, Swami, but not to
That
the
will see
extent.
after service of notice.
This has to be decided at this system, because under section 74, there's a limited period within which the appeal can be filed under the new act. Now, under this, in my view, comes within 60 days. So I need to convince your lordships on that issue, because the bench judgment of this Honorable Court states that if it is filed beyond the period of 60 days, then the appeal itself is not maintenance. So I need to convince your lordships on that issue. I'll make a brief written, kindly have it next week.
Yes, office objection is overruled. Leave this matter next week.
Serial number 21, Naveen Kumar S.
Please, my lord, I am for the appellant, my lord. I may be permitted to withdraw the application, my lord. That is the office objection which has been raised. I will have to file better application for temporary injunction, my lord.
ಆಯ್ತು ಬಿಡಿ. ಇದೆ ಎಲ್ಲಾ ಕೇಸ್ಗೂ ಇದೆ ಎಲ್ಲ ಪೆಂಡ್ರೈವ್ ಹಾಕ್ಬಿಟ್ರೆ ಎಲ್ಲಾರ್ಗೂ ಒಂದು ಪೆಂಡ್ರೈವ್.
The office objection is something else, mister, not regarding your IA.
Permit me to week's time, my lord. I'll comply the office objection.
Yes. At the request of counsel for appellant. Finally, 2 weeks time is granted to comply the top subjection.
Please,
Serial
my lord.
number 52, Manmohan PM for appellant, connected matter, R.I.T. sir.
If the
So for the appellant in the matter, MAP 7432, the connected. My lords, we have settled the matter, my lords. So we will file a memo in the next date, my lords.
7432, is it settled?
Between us is settled and the compromise has been filed and implemented.
No, now you want to withdraw, you withdraw it.
Yes, my lords.
That is what I would think, that this has become infructuous
No,
now.
I will say record your submission and dismissed as withdrawn, since matter has been settled out of court. File a memo to that effect. Why do you want
the
this?
senior is out of station, my lord. So his signature is necessary, my lord. So in
If you have an instruction, your signature is enough for memo.
the next date, I'll file.
I have no objection. Let the senior come and let him also.
Yes, when do you want?
My lords, any date.
Any,
My matter can.
1 week later.
My matter is good. And
No, that's what that will fix it. Today, anyhow, that now sitting itself is 11:30. Some other day.
Whatever is convenient to the honorable court.
No, except Wednesday and Friday, all other days are MFS matter.
Any days it is convenient because
The point at issue to be decided now
Yes.
is with regard to the office objection regarding maintainability.
Yes, that will also, we'll see that first.
That is, now, there is a little bit of.
when do you want next week?
Very well.
If this matter on Wednesday, Thursday, next Thursday.
But there is one submission, which I have filed a formal application in April 23, raising the very same issue for decision of this court with regard to maintainability. That application has not been put up here, and they have not filed objection to the application. Then we will know what they have to say and be ready for argument.
So have you served the copy to him?
Yes, yes.
Yes, learned counsel for respondent submits that they have filed an application.
I filed an application to say that the petition is not, appeal is not maintainable.
Yes, filed an application raising an objection regarding maintainability. Office to verify and put up that application.
This matter, 16.
Please.
16, yes. And then in the meantime, you file an objection.
Yes, but 16th would have some difficulty, but can it be on 15th, 15th or 17th? Subject to Lord's convenience.
20th.
Very well.
Yes, very well.
Great.
20th, my lord.
Yes.
Two weeks time will be granted. Complete the application.
At the request counsel for the appellant, 2 weeks time is granted to comply that obstruction.
Notice is served, my lord. As per the track record, my lord, the item is delivered to the respondent number 1 and 2. In spite of it, I served personally to the advocate on record in the trial court. That acknowledgement also filed before the court.
If court okay, yaar Ravi Samprati, respondent number 3 is served unrepresented. Ravi Samprati is directed to take notice. Senate counsel for the appellant is directed to serve 3 sets of copy, 1 set of appeal memo. The learned counsel for respondent number 3. 1 and 2 again.
1 and 2 served, 1 and 2 served. Even I served the copy to the trial court advocate as well as the track record shows that item is delivered to the 1 and 2. Copy put in. And also I served personally to the advocate on the trial court. Acknowledgement which filed before this court. Acknowledgement also.
Delivered on our track record, our court.
The acknowledgement also filed before this. The acknowledgement also filed before this court, which copy served to the trial court advocate.
No, trial court advocate service is not in a service.
And the RPID track record shows the item is delivered.
He filed along with that memo. ಯಾವ್ದು ಇದು ಹೈಕೋರ್ಟ್ ರೆಕಾರ್ಡ್
ಹೌದು ಅದ್ರಲ್ಲಿ ಟ್ರ್ಯಾಕ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಹೌದು
ಎಲ್ಲ ಇದೆ ಅದು ಯಾವ್ದ್ರಲ್ಲಿ ಬರುತ್ತೆ ಹೈಕೋರ್ಟ್ ಇವರಿಗೆ
ಆನ್ಲೈನ್ ತಗೊಂಡಿದ್ದಾರೆ ಸರ್ ನಮ್ಮವರು ಫಿಸಿಕಲಿ ಬಂದಿಲ್ಲ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಅಂತ ಮೆನ್ಷನ್ ಟ್ರ್ಯಾಕ್
ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಏನು ಸಂಬಡಿ ಅಷ್ಟು ಎಂತ
ಹೌದು ಸರ್ ಅವರು ಕೋರ್ಟ್ ಆಫೀಸ್
ಇದು ಹೈಕೋರ್ಟ್ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ತೆಗ್ದಿರ
ಹೌದು ಸ್ವಾಮಿ ಇಲ್ಲ ಆರ್ಕೆ ನಂಬರ್ ಕೂಡ ನಾವು ಬರ್ಕೊಂಡಿದ್ದೀವಿ
ಅಪ್ಡೇಟ್ ಮಾಡೋದು why they have not yes Senate counsel for the appellant has filed an acknowledgement to show that item has been delivered. That respondent number 1 and 2. He has also filed a memo. But that is not in the service. Three of the above. Service of notice to R1 and R2 is held sufficient. for this matter next. Yes, for admission.
I'm guessing for the interim, therefore any date may be fixed.
No, that you are appearing for whom?
Appellant.
No, who is appellant is the owner.
Appellant is the owner of the vehicle.
You now you serve a copy to that this thing, Mr. Ravi Sampath.
I'll serve any date may be fixed.
No,
The attachment warrant is issued. Therefore, any date may not next.
where execution has been filed.
Yes, my execution is filed and attachment warrant also issued.
Post this matter next Wednesday for admission.
Great.
Friday. Yes.
Bill number 25 disposed of, bill number 26 adjourned, bill number 27 Jayasima KP for appellant. Bill number 27 Jayasima KP.
Yes. Here. 2 weeks time is granted to comply the top subjection.
Bill number 28 adjourned, bill number 29 Akshay Kumar Bail.
KPID proceedings is filed. Objections is with regard to R2 to R1 and R5 to R18 are not made as party. And only R3 and R4 are challenging the said orders of attachment.
Council submission with regarding to that R1, R2, R5 to R4 and the objector before the trial court has not made a party. Where is that?
Impugned judgment starts from page number 9, my notes.
You are a respondent number
3 and 4, my notes.
3 and 4.
Please. Gayatri and Dakshai.
Who is that R1, R2, R5? R1, R2, R5.
R1, R2 and R5, R1 and R2 are one company and manager. R5 onwards are other employees of the company. And the objectors are not made as parties in the present appeal.
You are that. Who are you?
R2.
No, you are
R3
an
and R4, my lord.
R3 and R4.
Please.
Who are that R3 and R4?
They are general manager and employees in the company, my lord.
Company.
Please.
Why that other office bearers of the company has not been made as a party? They are
My
not.
lords, they are not challenging the impugned judgment, my lord.
What is that? What is that order which is passed?
Interim custody of the attachment of movable and immovable properties are made absolute by the KPID court, my lords.
You are representing the company. Company is not filing.
No, my lords. Company is not filing.
Then
I am filing. Even my personal properties are also attached along with the company's properties.
where is that? Where is that order? Where is the order posted?
Please. Respondent number.
The interim order of attachment passed by the government by the hereby made absolute regarding so on.
Page number
Properties,
75 is
leasehold
not
properties. Interim order of attachment passed by the government with regarding to the properties. The properties, the competent authorities is hereby directed. Yes, it is properties belong to that company.
Few of the properties belong to the company, my lords. Few of them are of the general manager. I am the manager in the company. My personal properties are also attached. The specific schedules are not produced, my lords. I will
Where is
place
that
it
to
on.
show that it is your personal property?
My contentions are recorded in the judgment.
What are that other office objection?
With regard to the valuation, my lords,
What is that valuation?
my lords, my submission, my lords, the petition which the competent authority files, my lords, they will place on record the valuation. That is not made part of the impugned judgment, my lords.
No, not judgment. It will be that part of that records.
The
You have to-
schedules are produced, my lords. Exact valuation is not produced.
You have to calculate and say what is that value.
Please, my lords, a week's time may be granted.
Yes. When is granted. Apply the top objection.
Bill number 30, apply and be reviewed for appellant. Number 30.
Yes, Prakash Shangadi. Appears. Finally, 2 weeks time is granted to comply the top objection.
Bill number 31, Nandegaula.
Rest 2 weeks.
Yes, at the request of counsel for the appellant. 2 weeks time is granted to comply the top subject.
Number 32, Nankyaledi PM.
At the request of counsel for the applicant, 2 weeks time is granted to comply the top subject.
Number 33, Insar Ahmad K. for appellant, Anand G.
Respond for the appellant. Just intend to hear the appeal finally. But the chair has not come. Monday or Tuesday, any day.
Office is directed to avoid service of records, post immediately after receipt of the records. Yes.
Now, it fixed, but
Date may be.
The records ಬಂದ ತಕ್ಷಣ post ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ದೀನಿ. ಮತ್ತೆ again, if it is fixed, if the records has not come.
No,
I
my lords,
directed
there is a conditional order passed by this honorable court in the last vacation, my lords. So with respect to that, they have to comply. They have to deposit 5 lakhs in the trial court, my lords. For that reason.
They have not deposited.
Not yet.
611 time is there up to 611.
611.
So date may be
611,
fixed, my lords, on 10th,
another
7, 8, 7th or 8th, my lords.
Second, third, any date,
No, that you have to deposit on 6/11.
611.
Post this matter on 9th.
Grateful, my lords.
9. Yes.
Now, before 6th, finally dispose that.
No, let us see if you are compliant that or.
Yes, my lords, 9th.
Once for all.
No, are you don't want to comply it or not? If you don't want to comply it, not comply it, then we know that what the order response. It shows that you don't want to comply. You want to take an interim order.
No,
In WP, same
not
thing
interim
has,
order.
same thing is.
I want a order finally.
No, that you
I'm
can't decide.
very sure that.
It is according to my roster. I have to
I'll
decide.
be
I
remain-
can't decide finally. Yes.
Grateful, my lords.
After taking an interim order by condition, now you want to overcome that order. You are saying that matter has to be disposed of. We'll see that whether you will comply it or not. Yes.
Grateful, my
Much
lords. 9th.
Yes.
Number 35, Mujura Integration for appellant.
I think the very relationship of employer and employee, your lordship, and also the interest aspect. A little 3 days delayed. I think today, during the course of the day, I am kindly permitted to file the IA, which is ready, your lordship. For
Non-furnishing of certified of having deposited the remaining amount payable. to the-
Aduswami Avaru, the total award amount of 7,59,000 we have deposited. They have raised objection on the part of the interest aspect is concerned. Other no deposit madilla anತಾರೆ. That itself is under challenge before your lordship.
No, that is true.
Yes,
You are, even if you are challenging entire judgment and degree, as per that Workmen Compensation Act, you have to deposit the entire amount there. That is the law.
I actually.
No, suppose if you are challenging that entire judgment and degree, you need not pay it. You have to deposit.
True, your
You have
lordship.
to deposit.
I'll do that. 1 week's time they can
Yes.
give. Meanwhile, may I request for the stay, lordship. They have
No,
filed the execution petition.
Appeal can be entertained only after depositing. That is the
Deposit-
mandatory under the statutes.
True, your deposit of main award amount we have already
No,
done.
that is not that entire amount you have to deposit. You deposit
Entire,
to.
ಅಂದ್ರೆ interest aspect
Yeah.
ಅಷ್ಟೇ ಮಾಡಿಲ್ಲ ಅಂತ ಅಲ್ಲಿ ಅವ್ರ
Is there any such distinction there? you see
it's
that-
only
No, that
discretionary
cannot be
power
a
of this
concession.
honorable court.
No, I
ಅಷ್ಟೇ
can't
my
deviate from the
consideration.
law. That's what that. Even that division bench, I think in all matters, they said you first deposit and then you have filed an appeal. All appeal has been dismissed. I
True,
think
your lordship, I
there is
understand
a
that.
judgment, Justice
that-
Veerappa,
I-
yes.
I do understand your lordship. I do agree with this opinion of this honorable court also. My only submission is that since the main award amount has already been done and the interest is very meager amount,
Oh,
this
is there any
honorable
such,
court can discretion, show the
where
discretion
is that
to
discretion?
pay what, as in the other MVC cases, 50%.
No. MVC cases, there is
I
no
do
law.
understand. I do understand.
In
your
your
lordship.
statute says that you have to deposit and file an appeal. MVC case, 25,000 rupees has to be deposited.
So actually, there is no relationship of employer and
know.
employee also.
That is the law.
And he was not holding the driving line. The employer himself denies that he was not working
Then
under
you
me.
challenge that validity, constitutional validity of that provision, then you.
Yes, your lordship.
Yes,
And a week's time I can live,
Yes.
10 days time I can live because it is Jumok division.
yes, 2 weeks time is granted to comply the top subject.
Meanwhile, our execution ಬಂದ್ರೆ ಸ್ವಲ್ಪ ಅದಕ್ಕೋಸ್ಕರ
ಕಟ್ಟಿಟ್ಟು ನೀವು ಕಂಪನಿಯರೇ ಆಗೋದಿಲ್ಲ ಅಂತಂದ್ರೆ how can you expect from others? You are
Yes,
in a
your lordship, like because it's a division office, it takes some time. That's all. It has to go to the head office. The check has to
No,
go to the
you
deposit.
call them and ask them to deposit, madam. Now that money can be transferred within 2 minutes. Where are you now?
But true, lordship, but so far as insurance companies are concerned, the amount has to be released from the head office itself.
No, if there is a case, there is an attachment, they can do it, madam.
I'll-
Otherwise, let them face an attachment.
Yes, your
Yes.
Number 34, Sundar Raman, English, the appellant, N.S. Ragendra.
Yes, yes.
Your Lordship, if I may, very short pass.
So ಇವಾಗೆಲ್ಲ ಅರ್ಧ virtually ಮೂಲಕ half day ತರ ಇದೆ.
Any date next week? Which date you want?
6, 7 ಆಗ್ಬೋದಾ?
7th.
7.
Short pass for me. No, that's two things. One is that afternoon he will seek for a Passover. Then we don't know whether today it will be reached or not.
And I file my objections also in the office.
If I shorter date.
No, that we said 7th.
7. Yes, great. Use this matter on 7.
Bill number 36, English, the appellant.
Yes, Unnikrishna, non-compliance of.
My lord, it's like last occasion, my lord, office objections are raised on MFA, which have complied. But yesterday, my lord, objections raised on an IA, which was filed subsequently. That is, I have not signed as 2 copies.
What is that?
It's produced along with appeal memo are to be stitched to the IA2 accordingly paginated. IA2 provision to be stated correctly. All document attested before to be attested before competent.
No, document is not attested by that commissioner.
But that was a document of from the website I taken of the honorable.
That has to be attested by that work commissioner. When you have marked an annexure, it has to be attested.
Should I accept notice for respondent number 1 and 2?
No, let him comply of his objection. Yes. If he hearing that on that day you can be present. If it is by any this thing we can.
Yes. I'll comply with it.
Yes. Which time is granted to comply the top subject. Will this matter on Thursday? Yes.
Number 37.
For the appellants, my lord. Office objection item number 1, my lord. I have made a note on the appeal memorandum, my lord, wherein, my lord, the appellant's name is misspelled in the plaint, my lord. That I have clarified in the written statement also. ಅದಕ್ಕೆ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ ನೋಟ್ ಬರ್ದಿದ್ದೀನಿ.
What is that the name of the appellant number?
ಅದು appellant ಹೆಸರು ಪೂರ್ತಿ ಇರೋದು ಮೊಹಮ್ಮದ್ ರಫಿ ಅಂತ ಸ್ವಾಮಿ. The plaint is at page number 31 here. He has mentioned Rafiullah. The correct name is Muhammad Rafi.
You are a defendant.
Yes, my lord. Defendant's appeal. This, my lord, we have
Father name.
Father name is also, they have not named, my lord. In the plaint, they said not known. In my verifying affidavit written statement, page 73, my lord. Page 73 is my verifying affidavit of written statement, my lord.
73.
Yes, my lord.
You have stated that.
Yes, my lord. Yes, my lord. Muhammad Rafi and father name, everything we have disclosed, my lord.
Yes.
The same thing.
Submission of learned counsel for the appellant in respect of office objection is accepted. Non-compliance of the office objection.
My lord, with respect to other items, my lord, my lord, extreme urgency, my lord, the office objections are not that I have not filed. I have annexed the later stage in Hinde Haki, Swami, Munde Haki, and the impugned order. Impugned order is at page 75, Swami. Adu first other Hakbeku and the other objections here. Extreme urgency in the matter, my lord.
Typed copy of the all manuscripts.
Adu manuscript and the memo is
herein were produced before all these documents has produced before
the portal ಹಾಕಿದ್ವಿ ಸ್ವಾಮಿ. ಇದಕ್ಕೆ ನಾನು separate memo ಇಂದ ಹಾಕಬೇಕಾಗಿತ್ತು. Like writ petition have produced on
in order to be stitched immediately after the memo. Proof to be furnished to verify dates and address of the appellant number 1 and 2. Address of so and so. In respect of office objection.
Grievance is extreme urgency.
Where is that in respect of their name?
Name address page 73 ದಲ್ಲಿ ಇದೆ.
No, which is that office objection?
ಈಗ office
challenge impugned order proof furnished to be shown.
ಅದನ್ನ ನೋಟ್ ಹಾಕಿದ್ದಾರೆ.
But office objection. Yes, is there any delay?
No delay, man.
Is there any caveat?
No caveat, man. Lord, my grievance is this, my lord. The defendants are hawkers, my lord. We run a street vendors, my lord. We do business on the street, my lord. I have been given permission by the BBMP, my lord. I am a disabled person, permanently 65% disabled person, my lord. I am doing a business, my lord. Wherein, my lord, my business and the plaintiff business both are the same, my lord. We are also running hotel business. he is also running a business. So what he says is he is incurring loss due to my business. He says I am illegally running a business without a license, my lord. I have produced the license, all these things, and the suit itself.
What is the?
Now, injunction, suit for permanent injunction, the relief what they have said, my lord, permanent injunction restraining from conducting business in the Kelidara. My lord, that kind of relief itself would not have been maintainable in view of, my lord, with the hawkers goskara kanunu Supreme Court, my lord, it says, my lord, it has to be, they have to file a writ petition before this honorable court, my lord. It, to the all across the state high courts ke direction ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ para number 21 my lord with respect to the hawkers my lord principles were laid down my lord para 21 my lord page 512 ಅಂತ ಬರ್ತದೆ
512
yes my lord
yes
with respect to this my lord 21.1 within 1 month from the date of the receipt of the order of this court, the chief secretaries of the state governments and administrators of the union territories issue all necessary instructions, directions to the departments concerned to ensure that the town vending committee is constituted city town level in accordance with the provisions contained in the 2009 policy for the cities and towns having large municipal more than town vending committee. Literally 21.7 million. Bottom of Bandre Swami. All the street vendors, hawkers shall be registered in accordance with para number 4.5.4 in 2009 policy. Once registered, street vendors shall be entitled to operate in the area. My license are produced, my lord. And the process shall be completed 21.8 within the country within 4 months. And then with respect to writ petition, last point, 22. The parties whose applications have remained pending before this court shall be free to institute appropriate proceedings in the jurisdictional high court. If so advised, the aggrieved party shall be free to file petition under Article 226 of the Constitution.
That is regarding that registration.
No.
Not that all case has to be filed in that.
No. If so, the aggrieved party shall be free to file petitions under the high court and regarding
No, aggrieved party and whose application has been rejected. No, how can he file a writ petition against you, mister, against a private party?
Not if.
How can that private party file a writ petition against that other private party?
If my license is
if
not
they are running without any license and all, he could have given a complaint to that authority.
Yes,
that may be say that
yes,
he can't say that he can't file a writ.
Previous,
Yes, what is that order passed by the trial?
Now, order trial court, what the trial court has passed, my lord, is page number 75, impugned order. Page 75.
Yes.
Whatever the defenses we had said, my lord, nothing has been considered. Para number 3, my lord, 76 and Birthday Swami. The defendant number 192 have erected stall measuring 10 into 15 and running beef fast food center, which is installed just opposite to the plaintiff's shop premises bearing number 506. Due to this, the plaintiff business is obstructed. And my defenses at para number 5, my lord. On the contrary, the defendants submit that they have installed the stall with the permission of the BPMP and there is no any obstruction to the plaintiff and the stall on which it is installed. It belongs to the Dargah property and the plaintiff is not a competent person to file a suit against the defendant 192. Further submitted, the only competent authority is BPMP to vacate the defendant. Hence, the plaintiff not having any right to institute. With regarding to this, my lord, whatever the defenses we had said, no observation, no reasoning, nothing has been produced, my lord. Now, para number 13 ali, al head para 13 fallu same head to Swami. Now, para number 15 ali, para number 15 is the reasoning what they give, my lord. The shops of the plaintiff which are in the Dargah property are existing prior to the installation of the stall by the defendant 192. As being the fact, the stall which is installed by the defendant 192 just in front of the shops of the plaintiff, obstructing to increase and decrease to the customers of the plaintiff, same is obstructing to this day-to-day business. Hence, injunction is granted, my lord. What the injunction is, my lord, defendants or anybody on their behalf restrained to carry out beef business, beef fast food, or any other business.
Where is your license?
License is at page number, my lord. 19, my lord. Page 19, my lord.
After taking the license,
please,
you have put up in a projection shed.
My lord, that is to the disability, my lord, to the disabled persons, my lord.
Disable order, you can do it whatever you want.
No, my lord. It is not like that, my lord. Page number 19 ಅಲ್ಲಿ hawkers license ಇದೆ. They have allotted a place also, man. They will
No,
allot
they
the
are not
place.
saying that you don't have any license.
They say
You have put up that projection beyond that area which has been allotted to you. That will obstruct its business.
my
That
lord,
is what is case.
my lord, now for grant of injunction, my lord.
Yes.
Balance, now the rich has been given shelter, my lord, and police get direction ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ, implement it ಅಂತ.
Day of dated 18th July 2023. Passed by the second National City Civil and Section Judge Nehal Bangalore in OS number 26268 of 2019. The next date of hearing. Issue immediate notice. In the meantime, appellant is permitted to comply the officer
Not by hand delivering. Please. Happening for appellant, my lordship. My lordship. Connected matters are coming on 2nd of November, my lordship. Meanwhile, a small correction is there, my lordship.
Yes. Week's time is granted to comply that office objection. Please this matter 2nd May.
2nd November.
November. Yes.
Number 38 to 43 adjourn. They will interrogate application matters. Number 44 adjourn. Number 45 Sharadamba years appellant. Number 45 Sharadamba year.
To the appellant to deposit court fee. Yes, also.
Number 46 is P. Manjunatha for appellant.
The parties have taken the file, my lord.
Why they have taken the file?
Why? Because the referring advocate died, my lord. What the party says, we have not given papers to me. We have given to the referring advocate. That is what they say.
No, have you taken the acknowledgement for returning that file?
Yes, they have, in the Wakalat, I have given no objection. I will file the Xerox copy of the Wakalat. 2 weeks time. But I think some other advocate might have filed it.
The GB Manjunath Learned Council submits that he has given no objection to engage any other council. Yes, Rupesh Kumar, advocate, has filed an wakalat on behalf of appellant. Office is directed to show his name.
Yes.
Somebody has filed, office is not.
Yes, yes, yes. So it has not been shown, not in the call list.
47 BK Chandrakeshava BS for appellant.
The applications are.
Convention filing, LR application may not.
LR application.
Since that application is in time, prior to first certified appointment. Setting aside that amendment to Barala, adak bartade delay illa anta. Bringing LRs. Who is that, Mr.?
Appellant number 2, my lords, the son of the testatrix. And he passed away, my lords, on 7th March 2021. That is, my lords, nearly 1.5 months after the final order of the trial.
That is
court.
Vivek.
Vivek, my lords. His paternal grandfather is now brought on record.
What is that?
We had sought for a probate of the will, my lord, of the mother of Vivek. That is the appellant number 2. Appellant number 1, my lords, is the brother. It was.
What has happened before that? LSC court.
Lord, it was rejected on the grounds, my lord, that it is a suspicious will that even though the testatrix has a son, she has bequeathed the property in favor of her brother. This is the ground that. But
have you examined that any attesting witnesses and?
Yes, my lord. Yes, all attesting witnesses were brought before the court. The court passes no observation with regard to, my lords, the execution of the will.
It only goes on the premise that, my lords, the will is suspicious because it is one that is, it is not registered. Second, my lords, that it is not a registered will. Second, my lord, that even though there was a son, that is the appellant number 2, the property stands bequeathed in favor of her brother, appellant number 1. Her husband was already passed away. Now, my lords, the court fails to observe that appellant number 2, Vivek, was made a party. However, he was suffering from immense ill health.
No, that who is her son?
Appellant number 2, who passed away, my lord.
No, he is also there.
He was there. Before the trial court, he was there.
No, that who has executed that will?
He did not, my lords, lead any evidence because.
No, who has executed that will?
Mother, my lord.
What is her name? Mother of Shankar.
No, my lord. Mother of Vivek.
Mother of Vivek.
And sister of Shankar, my lord.
Sister of Shankar.
Yes, Veena N. Kumar.
Now that brother claiming that
yes, my lord.
will is in his favor.
In the will, there was a specific direction that, my lord, he should take care of the welfare of the son also. Son was going through certain addiction problems and he was going some depression and all this.
Now he is no more.
Now he is no more. This is the.
Now who are the teller?
He is the paternal grandfather.
Paternal grandfather on
the class 2 here nalli avare bartare.
Let us see. Yes. Yeah, 3 of 2021 is filed for bringing LRs of deceased appellant number 2. There is that affidavit for the reason stated in the accompanying affidavit. Yeah, 3 of 2021 is allowed. LRs of deceased appellant is permitted to come on record. The net counsel for appellant is permitted to amend the cost title.
Lord, it's already amended. It's already amended. Appeal baruvagle, he was no more.
Then why that application now?
Because
only you have to file an application for
it was in the midst of my lord, after the order passed by the trial court and before we preferred the appeal, Vivek had passed away, the appellant number 2. Therefore, yes, my lord,
IA is allowed permitted to come on record. IA 1 and 2 of 2021 is dismissed as not present.
Please.
Yes. Suppose this matter for admission.
My lord, appear for the appellant. Appeal is filed challenging the award, judgment award dated 21/7/2017. Lord, there are connected reference applications in this common judgment. We have filed appeals against all these 9 connected applications. Lord. 2 of them come before by virtue of the pecuniary jurisdiction, 2 of them come before the division bench of this honorable court, and 2 of them have been stayed by the division bench of this honorable court. My respectful submission is this also has to be tagged. I filed a memo before the division bench, and the division bench had ordered for tying these matters.
Where is that order?
This is MFA 2343 of 2022. Last registry is directed to list this matter along with the appeals mentioned in the memo. Memo is placed on record. List this matter. Big connection in the legal process. Now,
memo is placed on record. Number hakilva.
Memo hakide Swami. I'm trying to ascertain in the registry.
After district museum court, registry is directed to leave this matter along with the appeal mentioned in this memo. Memo ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
Memo file ಮಾಡಿದ್ವಿ. Right now I don't have it with me. Yes, but this is also connected with the
Net counsel for appellant has submitted that within bench of the court in MFA 2343 of 2022 has directed post this matter along with that. I have directed the present appeal 2344 of 2022. Next matter also.
No, next matter is.
I am directed to post this matter along with that NFA 2343 of 2022. Please to verify and post this matter along with NFA 2343 of 2022 before the division bench having an agreement.
Not this matter. The reference court has relied upon an unmarked sale deed that your lordships will find at page number 34. Paragraph number 24, my lord. The respondents have acquired lands during the year 2013-14 that the claimants in LSC numbers 168 and 169 have produced sale deed unmarked of Sanehalli village pertaining to the year 2015-16. Hence, the relevant year of acquisition is to be taken as 2013-14. In 2015-16, the market value, my lord, my submission is that the reference court has relied upon an unmarked sale deed. I do not have the benefit of going to the sale deed, and this is subsequent to the year of acquisition. Under the new act, the law is very clear. The land acquisition officer has to go through the year prior to the year of the preliminary notification to determine the market value of the land. Either they have relied upon a subsequent year's sale deed and 10% depreciation on the market, they have enhanced the value of the acquired land, which is ultra the provisions of section 26 of the land acquisition.
Land acquisition officer
My lord,
how much that land acquisition officer has awarded? What is the enhancement?
The valuation slip is at page number 9.
Per guntas 8,000.
This one.
New West put is first one.
Now 1,88,733 is the amount that was determined.
Acre.
That is for the 0.32 guntas as to 1,88,733. That has been enhanced by 8,775 per gunta.
New West ಮಾಡಿದ್ರು ಒಂದು ಗುಂಟಕ್ಕೆ.
Swami, ಒಂದು ಗುಂಟಕ್ಕೆ. $5,897.
ನೀವು ಅದನ್ನ 8,000 ಮಾಡಿದ್ದಾರೆ.
ಹೌದು ಸರ್. And added to that solatium additional.
That ಬರುತ್ತೆ, but is it not reasonable?
My lord, we are on the principle of the law that the amount of compensation has to be decided in accordance with the notice. My lord, in similar cases, your lordships has
Delay. Here is there is a delay.
Your lordships has directed stay subject to deposit of 50%. And
where is that? Yes, how did you notice? Yeah. Statement and award dated. I'm
sorry.
50/12/2021. Please. But signed on 17/12 ಅಂತ ಹೇಳ್ತೀರಾ ಏನ್ರಿ ಅದು?
Also, award is signed on.
Date of sign is the date of award, Mr.
What we have experienced is that there is a considerable delay when the award is signed. Though that
12 sign ಮಾಡಿದಾರಲ್ರಿ?
The award is signed on.
Award judgment sign ಮಾಡಿರೋದು 15/12.
House.
Yes. Stay of judgment dated 15/12/2021. Passed by first additional district session judge. LAC number 168 of 2017, subject to condition. Appellant has to deposit 50% of the award amount before this court within 4 weeks.
Number 50, floating in 50 for appellant.
Appeal under section 37 of the Arbitration and Conciliation Act challenges section 34 by the Honorable District Judge Court.
Why?
As far as IA number 2 is concerned, I'm not pressing that. Already NHA is appeal by the National Highway Authority of India. NHA is a party, not thinking about it. By oversight, IA 2 is filed for permission. And highway itself is the party. I'm not pressing that IA 2. As far as IA number 1 of 22, there is a delay of 55 days.
No, what is that?
Actually, respondent number
Arbitration suits.
Respondent number 1 passed a general award fixing the compensation of rupees 2,70,000 per cent. That acquisition pertaining to 2008 and 2013.
No, that what is that award passed by your land acquisition officer?
Yeah, land acquisition officer passed award fixing the amount for 2008 acquisition 2,70,000 per cent.
Arbitrator ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ?
Arbitrator 3,13,600 for
appeal,
all the land. For all the lands.
That has been dismissed by
challenge that we have filed a section 34 appeal before the district judge court, and same has been dismissed and confirmed by the Telco. Now they might file
issue notice. There is a delay. Yes. Issue notice on IA ಯಾವ ಪ್ರೆಸ್ ಮಾಡಲ್ಲ ಅಂದಿದ್ದೀವಿ?
IA number 2
IA number 2
for permission.
Yes.
By board side it has been
Dismissed as not press. Notice. Yeah.
IA number 2 only, my friend. For permission.
Yes, 2 is dismissed as not press.
Yes.
In respect of other IAs, notice has been not.
Number 51, reverse investigation appellate.
No, the delay of 119 days, preferring the appeal.
Notice.
Much appreciated.
Number 52, Mr. Ananda Krishnamurthy,
easement arrangement, pathway. They notice will be.
Notice.
Number 53, Mr. Shantapan, they have 23 days in the fighting.
Notice.
Please.
Number 54, authority for appellate.
For appellate. Blood, 1 week time may be granted. Is for reason I applied the BBMP Kata and the KEBP. That is the blood, the sale date 2004 as per the general.
That is not relevant here. Here we are deciding
that relevant point, blood, from the 2004 till the 2021-22, standing in the name of current bill and the BBMP Kata in the name of the plaintiffs.
That is wholly false. Produce the Kata.
I will produce,
No, you argue on that. It is not an this thing on interlocutory application. But it's not
for the prima facie, the plaintiff is in possession of the property in regard. In case if the sale deed is executed 2004 by the husband in the name of the wife, the Kata was not affected. On the current bill, the prior to 1993 has obtained.
You argue that
that 2 documents is need. For 1 week, I applied vacation and the holidays in 1 week.
See, whatever you have produced before the trial court has to be looked into. We cannot do it. See, how the trial court has granted an interim order, that has to be seen.
Interim order is not granted. Interim order is not granted. Interim order, my applications for not to interfere and not to alienate the property, nature of the suit for the declaration and permanent injunction filed by the plaintiffs.
Show me that why it is wrong. That's all. No, mister, you are taking an interim order and violating that. You are
violation means this honorable court directed to maintain the status quo in respect of the property is concerned for the position at the title.
That is the allegation that
till today, we are not violated. Whatever the court has produced before.
Mr. Reddy,
yes.
After considering your submission, interim order has been granted ex parte.
Yes, please.
They have a right to file an vacating.
Yes.
They have filed an application for vacating. You argue, we'll consider. If they make out in a case, we'll vacate it. Otherwise, the interim order will be confirmed.
Yes, please. And one more application we have filed. There, the second respondent has sold the property, has gifted the property, the suit properties to his own daughters without any permission from the court during the pendency of the suit. Already the deeds has been registered.
No, all that
we have filed impleading application.
No, all that will be protected under section 52.
Yes,
Any alienation will be
Yes.
They are not, they will not get
Yes.
any right. Why do you want
Yes,
all
yes,
this?
yes.
Now that if they want to alienate, if they are alienate, then they will suffer that.
Yes.
Then what else you want then? Then you are saying that you are not doing anything, they are not doing anything. Let the trial court dispose of that suit.
Yes.
Hello,
Then-
my only submission is this one. They are not in possession.
What is that wrong in that order passed by the trial court?
That
Yes, what is the suit for?
suit for declaration and permanent injunction filed by the plaintiffs, both husband and wife.
Declaration.
Declaration.
What is the relationship between the?
Well, relationship that the plaintiff has acquired the one side in the year of 1993 from the the third respondent. Third respondent in the society has allotted the site in favor of the first plaintiff, one side. Another site allotted to the his wife in the
No,
second plaintiff.
Society, you are an allotee.
Allotment. Allotee.
When it is allotted?
Allotment is 1993 milad. Sale deed has been executed with the society in favor of
sale deed.
Sale deed is dated 1993. 18/10/1993. And two sides involved in the suit plan. One site is in the name of first plaintiff, another site in the name of his wife is second plaintiff.
Then what is the sale deed? Both sale deed is
Both sale deeds, individual sale deeds.
on same day.
Same day. And same measurement, site number is different.
What is the site number?
Site number 250 J 15 one side. Another side 250 J 60. Adjacent properties. The third respondent is allotted. Subsequently, after payment of the amount, the sale deed has been executed.
Yes.
2020, 15/12/2020, the appellants have mortgaged the property for 3 lakhs. Individually executed the mortgage deed
in favor of
the one backed land. For each site is 3 lakhs. Subsequently released the mortgage on 10/2/2002. On that 10/12/2002, the first respondent is a far relative to the plaintiffs, has executed the general power of attorney to sell the property. First respondent, in favor of the first respondent. Both plaintiffs have executed the power of attorney.
You have executed a power
Yes,
of attorney in favor of defendant number 1.
Defendant number 1.
When?
On 16/6/2004.
16/6/2004.
10/12/2002.
Sorry, 10/12/2002.
10/12/2002. 2002, you have executed
the general power of attorneys individually in the two sides by the first plaintiff and second plaintiff. Two general power of attorneys executed in the name of the first defendant. For such the new buyer and the sell the property as admitted in the written statement also for the sake of their relationship. They are in from the Rajasthan. Both are Rajasthan. In the business they are doing in the Bangalore. For sell the property, this power of attorney executed. There is no sale consideration in the power of attorneys. There is no any sale agreement separate executed by the plaintiffs. But on 16/6/2004, the first defendant, the general power of attorney holder, has created the sale deeds individually, 2 sale deeds in the name of his own wife.
That is the second defendant.
Second defendant, his own wife, 16/6/2004.
Sale deed.
Sale deeds. 2 individual sale deeds.
Yes.
In the sale consideration is 1,50,000 shown. For received the first defendant on behalf of his wife from the wife.
Yes.
But this sale is not affected in the revenue records from 2004 to 2021. The BBMP Kata is standing in the name of the plaintiffs, and when he has obtained the electricity connection to the property, it was continued. He is not aware of the sale deeds is concerned. But he has issued the notice, legal notice,
to the defendants. That is a legal notice on 26/2/2020. Legal notice.
20. Yes, what is that legal notice?
Legal notice.
Why?
Blood, he has interfered the position. Then he has verified the encumbrance certificate, all these things in the legal notice 158 page number. He has the foundation for filing the case. Then he has came to know the sale deeds has been created by the first defendant in favor of his wife. Thereafter, this is the as allegations in the legal notice. It is a fraudulent deed. It is a cheated. The document is created without the knowledge of the plaintiffs.
Yes.
But the suit has been the notice has been issued.
Yes.
The reply notice has been issued. But in the reply notice, he has came to know the knowledge about 2012, Malad. 2012, the fresh allotment letter has been issued by the third respondent in the name of the second respondent. Fresh allotment.
Same side.
Same side. Fresh allotment letter has been issued.
Then what is the date?
2012, Malad, 10/12/2012.
Yes.
Position certificate has been issued.
Position certificate allotment, right?
Position certificate and allotment both has been issued by the third respondent in the name of second respondent.
Yes.
In their reply legal notice, they have stated.
Yes.
But thereafter, 27/9/2017, supplementary deed has been executed by the third respondent in the name of the second respondent. That was kept pending after issuing the notice in 2020 before filing the suit. After filing the suit, but after the filing the suit, within the 2 days, that deed was issued by the sub-registrar in favor of the second respondent. Even though after issuing the notice, they are aware of that. There all these documents are created and
then what has happened?
That legal notice that N1 month.
I thought
Yes.
that is not. I am not deciding a suit.
Malad, consideration before this honorable court, Malad. The plaintiffs has made out prima facie case. They are the defendant number 1 and 2 and defendant number 3 have filed both of the 2 applications independently for rejection of the plaint on the ground the suit is barred by law and they have not paid the court fee and there is no cause of actions. But that the 2 applications individually dismissed by the honorable court in the month of March 2023. Subsequently, they have executed the gift deeds in favor of their daughters.
Yes.
But for the consideration of the interim order, the Kata certificate and the plaintiff has paid the property tax and the current bill, that is the annexures has not been considered. Their only consideration, sale deed has been executed. It is a matter of the trial. Therefore, you are not.
You read that reasoning given by the plaintiff.
Yes. Para number 12, Malad, page number 11. Thus, what could be gathered from the rival contentions of the parties is that according to the plaintiffs, they had though authorized the defendant number 1 earlier to sell the suit properties to pay the consideration amount to them. He has paid to complete the same, but subsequently by misusing the GPA got created the disputed sale deeds in favor of his own wife, defendant number 2, which was also supported by the defendant number 3 society. On the contrary, defendant number 1, 2, 3 have pleaded the jurisdiction with regard to the sale transactions affected in favor of defendant number 2. Therefore, certainly all the rival contentions leads to material disputed issues which require to detailed trial. Therefore, undoubtedly, it could be said that the applicants, plaintiffs would make out prima facie case to go for the trial on the merits. But trial could come to conclusion.
You read further.
Yes. However, we are making out prima facie triable case. It is not the sufficient since the applicant has to further make out prima facie grounds even to seek the temporary injunctive relief to substantiate their claim. The plaintiffs have produced the certain documents. The first two documents are the copies of the disputed sale deeds executed in favor of the defendant number 2 by the defendant number 1 representing himself as the GPA holder of the plaintiffs. Subsequent records produced before the court by the plaintiffs are the Kata certificates and Kata extracts which are initially shown to be standing in the name of the plaintiffs. As regards other documents, they are the two encumbrance certificates showing the disputed sale transactions between the defendant number 1 and 2 with respect of the social properties. The other documents are copies of the legal notice issued by the plaintiffs to the defendants. As against the documents produced by the plaintiffs, defendant number 1 and 2 have also produced the copies of the GPA, which were executed in favor of the defendant number 1 by the plaintiffs. The separately with respect of the suit schedule properties, defendant number 1 and 2 have also produced the earlier encumbrance certificates standing in the name of the plaintiffs. Subsequent, the encumbrance certificate is in the name of defendant number 2. Pursuant to the execution of the disputed sale deed in her favor, they have also produced the copies of the few cash receipts 28/2003 shown to have been issued by both plaintiffs according to defendant number 1 and 2. Under these cash receipts, both plaintiffs have duly acknowledged the receipt of the amount from the defendant number 1 and 2 with respect of the value of the properties. As regard the other documents produced by the defendant number 1 and 2, they have include the copies of demand notice issued by defendant number 3 in favor of defendant number 2, calling upon her to pay the amounts which were payable to BDA. The other documents are with regard to the allotment of scheduled sites in her favor by the defendant number 3. After she complying with the demand made by defendant number 3 with regard to the completion of the formalities, they have also produced the copy of the confirmation deed, supplement deed executed by defendant number 3, society in favor of defendant number 2, confirming her title, conveying the scheduled property in her favor, which was followed by the possession certificate, no objection certificate, no due certificates issued in her name. It is relevant to note that the plaintiffs have not denied the fact that initially they had executed 2 GPA separately with respect of the suit properties in favor of defendant number 1, authorizing him to sell the suit properties to meet their financial needs. Pertinently, the said GPA has not been produced by them, which would have been the material piece of evidence to ascertain the result of the said documents. However, defendant number 1 and 2 have produced the copies of the said GPA before the court. They are the registered deeds and the same have not been disputed by the plaintiffs. Even the defendant number 1 and 2 producing the same before the court, the recitals of the said documents are equally relevant to be referred. Under the above said GPA, the plaintiffs had authorized defendant number 1 to do all the acts and deeds in relation to the suit properties, which also include the authority to appear before the government, other statutory authorities to submit the applications, affidavits, or other connected documents before the concerned authorities to enter into the transactions, agreements, etc., which are contained in clause number A and C. However, the further recitals, clause number D, specifically authorized defendant number 1 to transfer the suit properties by way of the sale or any other modes and to sign all such documents. Further, clause number E specifically authorized defendant number 1 to receive the consideration amount after the sale, convenience, and to issue the acknowledgements and receipts for the same. Rest of the recitals further authorized to deal with the suit properties absolutely. It is material to note that none of the terms of conditions contained in the above said GPA specifically require the defendant number 1 to do those acts, deeds only on behalf of the plaintiffs, nor this is any such recitals to effect that consideration amount has to be received by him on behalf of the plaintiffs and has to remit the same to them after completion of the sale transactions. Therefore, at this juncture, prima facie, it is shown that authority conferred on dependent number 1 by the virtue of the GPA has an absolute authority to deal with the suit properties. It is further to be noted that though the plaintiffs have repeatedly alleged that after sensing modified intention dependent number 1, they issued him legal notice to cancel the said GPAs, to return all the original title deeds of the suit properties, etc. But no documents were produced before the court to prima facie show that they had legally cancelled or they revoked the GPAs. On the contrary, they have produced the copies of legal notice issued dependent number 1, 3/2020 for the first time, stating that said GPS has been cancelled by the said notice, where the disputed sale deeds in favor of dependent number 2 have been executed in the year of 2004. The conduct of the plaintiffs have also requires attention of this court. It is material to note that GPS refer to the supra or the registered deeds. Therefore, presumption arises as to their credibility, and hence the plaintiffs now cannot allege that dependent number 1 was not authorized to sell the suit property under these GPAs, nor they are permitted to retract from contentions these deeds. Moreover, the disputed sale deeds in favor of dependent number 2 have come to existence in the year of 2004, which were also registered deeds, under which this is the deemed notice under the law of such transactions to all the public. However, no satisfactory explanation is offered by the plaintiffs for not taking any action against dependent number 1, challenging the said deeds at the earliest point of the time. One more material aspect which invites consideration at this juncture is that though the plaintiffs have seriously alleged that no consideration has been passed on to them under the disputed sale deeds, either from dependent number 1 or from dependent number 2, therefore they are not to bound by these transactions, but dependent D1, D2, they have produced the copies of the 2 cash receipts showing the receipts are an amount 1,30,000 under each of these receipts by both the plaintiffs. With respect to the sale of the suit properties, there is no explanation offered by the plaintiffs with regard to these materials documents. No doubt at this pre-trial stage, court cannot go into the merits of the each and every document, nor can give any finding. Not finding.
Yes,
But
I've gone through that judgment, yes.
Yes, the consideration, Malad, he has produced the Kata certificates.
No, you have given a GPA.
Yes, Malad.
Given all authorization for alienation.
Malad, it is admitted.
On that basis, they have alienated. What is wrong is that you have not said that they have no power to alienate.
They have signed the sale deeds, kindly see.
They have
Don't say that, they've signed the sale deeds.
General power of attorney is executed for the sell the property. It is a close relative, it is a far relative. It is admitted in the written statement also. Malad, yes, the executed sale deed in his own wife.
Without maybe
yes, Malad, without the knowledge of the
then no GPA kodade adike nimige knowledge.
Yes, that the sale deeds, Malad, if they executed the sale deeds, if they executed the sale deeds on the legally GPA, that deeds has been not affected in the documents from the 2004 to 2021.
Yes.
Therefore, he is not aware of
you see, you have given a absolute power. You need not aware. You have given an absolute power to alienate. There is no clause saying that amount has to be remitted to you. That is also not there. That is what discussed by the trial court.
Yes, Malad, the
presumption is that you have taken a money and given a GPA.
Malad, that the receipts has been created.
No.
The amount receipts has been produced.
No, Mr.
That was not admitted.
If there is no such clause in that, presumption is that you have taken the money and given absolute right to alienate. Otherwise, who will give a power to alienate, Mr.?
Malad,
they will, after taking such a power, they can alienate to their son or daughter, whatever they want.
For the market value, execute the sale deed, and is a label of the GPA holder to inform that this is the sale.
Now, anyhow, that there is already an alienation. All that has to be decided by the trial court. Let the trial court decide.
But the sale consideration in regard to his own wife for the less than the
ಆಯ್ತ್ರಿ
market value.
ಅದನ್ನೆಲ್ಲ ಎಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕು ಟ್ರಯಲ್ ಅಲ್ಲಿ ಡಿಸೈಡ್
And
ಆಗಬೇಕು
moreover, my point,
whether they have given to their own son is the wife is wrong, whether consideration is there or not, everything has to be decided by the trial court. Now they have already alienated to that second defendant. I will say that there should not be any further alienation. Trial court may be directed to dispose of the. Yes.
Can we see Manoj?
for
page 82?
the directed to the trial court.
I will
Malad,
direct the
dispose the
trial court.
matter, not to alienate the property.
That cannot
The
be
time may be,
asked
time may be
also.
fixed.
And also,
See that here what is their argument?
Manoj, firstly, this is not a suit for declaration. It's a suit for declaration that the sale deeds are not binding. It's not for declaration of title.
Yes.
Can we see page 44 of the appeal memo, the claim relief? It was declaration regarding the documents, not regarding title.
Yes.
Then your lordship will be kind enough to take page 82, which is a general power of attorney,
Yes.
which the trial court rightly records was not produced by them, although it was supposed to be produced.
Yes.
It
80.
is 82.
Yes.
It is a registered power of attorney. Kindly see page 88.
Yes.
Clause B and E. To transfer and convey by way of sale and to receive the consideration. Both the clauses are.
No, you have given that power to receive consideration also.
Please, my lord, this is under section 202 of the Contract Act, an agency coupled with interest. And it is registered.
Yes.
Then kindly see, my lord, a second GP of the same nature at page 97 by the appellant number 2.
No, same, similar.
Same,
Yes.
at page 103, clause B and E. Agency coupled with interest.
Yes.
Now kindly see, my lord, page 112 is the absolute sale deed, which the respondent number 1 as GPA holder of the appellant has executed in favor of his wife, who is the respondent number 2. Kindly see page 122.
Yes.
Appellant number 2 is one of the witnesses.
20.
122.
Yes.
Witnesses Radha Devi, none other than appellant number 2. So the fact that they
Where is that Radha Devi?
Radha Devi witnesses, Manoj.
Witnesses ಒಂದು ಹಿಂದಿಲಿ ಇದೆಯಲ್ಲ, that is.
Radha Devi and the first one.
No, page 122.
Please, Manoj, that's the last page of the sale deed.
Yes.
Radha Devi, your lordships are able to trace that. Witnesses scheduled in first name.
Gundachar.
This is at page 120.
Page 115 ಅಲ್ಲಿ ಇದೆ sir, witnesses.
115.
Coffee ಕೊಟ್ಟಿರೋದ್ನ page nation correct ಇಲ್ಲ. Anyway, 122.
115. Witnesses, ಹೆಸರು ರವಿ ಕೆಂಗೇರಿ ಬೆಂಗಳೂರು, ಆಮೇಲೆ ವೆಂಕಟೇಶ್.
Radha Devi is one of the witnesses.
Venkatesh Rao.
Complex.
Witness.
Let me submit.
No, that where is that Radha Devi?
Your lordships are able to get the absolute sale deed in an annexure G.
Start from page 112.
Please, my lord.
Yes, it is dated 16/6/2004.
Please, my lord. At 122.
122 witnesses.
Radha Devi, Hindi null sign it.
Hindi, that's what I am asking. What is that name? I can't
Radha
read.
Devi.
It is Radha Devi.
Please, my lord.
That's what I am asking. It is there.
Yes.
It is in the Hindi.
Radha Devi, that is none other than appellant number 2.
Yes.
So
Yes, is it Radha Devi?
Radha Devi's signature is a disputed blood. They are
No,
not aware of this.
here it is written as Radha Devi.
ಇದರಲ್ಲಿ ಯಾರು ಬೇಕಂದ್ರೂ ಸೈನ್ ಮಾಡಿಕೊಂಡು ಇದನ್ನು ಪ್ರೆಸೆಂಟ್ ಮಾಡಬಹುದು. ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 115 ಅಲ್ಲಿ ಇದೆ. ಅವರು ದೇ ವಿಟ್ನೆಸಸ್ ಶುಡ್ ಬಿ ಪ್ರೆಸೆಂಟ್ ಅಟ್ ದ ಟೈಮ್ ಆಫ್ ದ ರಿಜಿಸ್ಟ್ರೇಷನ್. ದಟ್ ಇಸ್ 115. ರವಿ ಮತ್ತೆ ವೆಂಕಟೇಶ್ ರಾವ್ ಅಂತಾನೆ ಇದ್ದಾರೆ. ಸೆಕೆಂಡ್ ವಿಟ್ನೆಸ್ ಇನ್ ಪೇಜ್ ನಂಬರ್ 112. ಸೆಕೆಂಡ್ ವಿಟ್ನೆಸ್ ವೆಂಕಟೇಶ್ ರಾವ್. ದಟ್ ವೆಂಕಟೇಶ್ ರಾವ್ ಸಿಗ್ನೇಟರಿ ಇನ್ ದಿ ಪೇಜ್ ನಂಬರ್ 113. 115 115 ಬಾಕ್ಸ್ ಇದೆ. ಹೆಸರು ಮತ್ತೆ ವಿಳಾಸ ಸಾಕ್ಷಿದ ಕ್ರಮ ಸಂಖ್ಯೆ 1 ರವಿ ಕೆಂಗೇರಿ ಬೆಂಗಳೂರು. ಸೆಕೆಂಡ್ ವಿಟ್ನೆಸ್ ವೆಂಕಟೇಶ್ವರ ರಾವ್ ಬೆಂಗಳೂರು. ಅವ್ರದ್ದು ಸಿಗ್ನೇಟರಿ ಇದೆ ಸೆಕೆಂಡ್ ವಿಟ್ನೆಸ್ ಪೇಜ್ ನಂಬರ್ 112 ನಲ್ಲಿ
112 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
112 ಕೆಳಗಡೆ ವಿಟ್ನೆಸ್ PN ವೆಂಕಟೇಶ್ವರ ರಾವ್ ಸೆಕೆಂಡ್ ವಿಟ್ನೆಸ್ ವೆಂಕಟೇಶ್ವರ ರಾವ್.
112 ಅಲ್ಲಿ ಏನು ಇಲ್ಲ ರೀ. 112 is the first page of that cell deed.
ಅಲ್ಲ 115 ಅಲ್ಲಿ ವಿಟ್ನೆಸ್ ಲಿಸ್ಟ್ ಇದೆ. ಹೆಸರು ಮತ್ತೆ ವಿಳಾಸ
115
115 ಹೆಸರು ಮತ್ತೆ ವಿಳಾಸ. ಫಸ್ಟ್ ವಿಟ್ನೆಸ್ ಯಾರಂದ್ರೆ ರವಿ ಕೆಂಗೇರಿ ಬೆಂಗಳೂರು. ಸೆಕೆಂಡ್ ವಿಟ್ನೆಸ್ ವೆಂಕಟೇಶ್ವರ ರಾವ್ ಬೆಂಗಳೂರು ಗಿರಿನಾಥ್. ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 122 ಲಾಸ್ಟ್ ಪೇಜ್ ವಿಟ್ನೆಸ್.
ಎಲ್ಲಿದೆ ಇದು ವಿಟ್ನೆಸ್ ಅಂತ?
ಇದರಲ್ಲಿ
ಹೆಸರು ಮತ್ತು
ವಿಳಾಸ
ಯಾರ್ದು?
ಅಟೆಸ್ಟಿಂಗ್ ವಿಟ್ನೆಸಸ್
ಎಲ್ಲಿದೆ ಆ ತರ?
ಅಲ್ಲ, ಹೆಸರು ಮತ್ತೆ ವಿಳಾಸ ಸಾಕ್ಷಿದಾರ ಗುರುತಿಸಲ್ಪಡುವರು ಅಂತ ಮೇಲ್ಗಡೆ ಇದೆ. ಗುರುತಿಸಲ್ಪಡುವರು ಅಟೆಸ್ಟಿಂಗ್ ವಿಟ್ನೆಸಸ್ ಅಂತ. ಗುರುತಿಸಲ್ಪಡುವರು ಕ್ರಮ ಸಂಖ್ಯೆ 1. ಅದರಲ್ಲಿ ಹೆಸರು ಮತ್ತೆ ವಿಳಾಸ ಯಾರು ಗುರುತಿಸಲ್ಪಡುವರು ಸೇಡಿನ ರವಿ ಕೆಂಗೇರಿ ಬೆಂಗಳೂರು ನಂಬರ್ 1. ನಂಬರ್ 2 ವೆಂಕಟೇಶ್ವರ ರಾವ್ ಬೆಂಗಳೂರು ಅಂತ ಇದೆ. ಅವ್ರ ಸಿಗ್ನೇಟರಿ ಇದೆ PN ವೆಂಕಟೇಶ್ವರ ರಾವ್. ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 122 ನಲ್ಲಿ ಲಾಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ PN ವೆಂಕಟೇಶ್ವರ ರಾವ್ ಅವ್ರದ್ದು ಅಡ್ರೆಸ್ ಆ ಸಿಗ್ನೇಟರಿ ಬರೆದಿದ್ದಾರೆ ಬೆಂಗಳೂರು 50. ಅಟೆಸ್ಟಿಂಗ್ ವಿಟ್ನೆಸಸ್ ಬಂದು ರವಿ ಮತ್ತೆ ವೆಂಕಟೇಶ್ವರ ರಾವ್. ಈ ರಾಧಾದೇವಿ ಅಂತ ವಿಟ್ನೆಸ್ ಗೆ ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಅವ್ರದ್ದು ಪ್ರೆಸೆನ್ಸ್ ಇಸ್ ನಾಟ್ ರಿಕ್ವೈರ್ಡ್ ಫಾರ್ ದ ರಿಜಿಸ್ಟ್ರೇಷನ್. We attesting witnesses should be present at the time of the registration. ಅದಕ್ಕೆ ಇದನ್ನ ಅಡ್ಮಿಷನ್ ಇದೆ ಅವ್ರದ್ದು ಅವ್ರು ಕೂಡ ಇದನ್ನ ಕನ್ಸೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳೋದಕ್ಕೆ ಒಂದು ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ವಿಟ್ನೆಸ್ ಯಾರು ಸೈನ್ ಮಾಡ್ಕೋಬಹುದು.
Yes.
Below 133 similarly Ratan Lal's name is also there. 133. Even if they had not signed as witnesses, it does not matter. After they gave the registered GPA, which was absolute in nature, they retained no interest in the property.
Yes.
Now,
wait, Mr. Let him just please.
Sorry.
Yes.
Kindly see, the sale deed was executed with their knowledge.
Yes.
Thereafter,
Yes.
kindly take my statement of objections.
Yes.
And these two sites are located in the Vishwa Bharati House Building Cooperative Society.
Yes.
There were several litigations with regard to this cooperative society.
Yes.
After the litigations were resolved, the sites came to be renumbered.
Yes.
As 3766 and 3767.
Yes.
Therefore, my lord, Annexure R1, page 11 of my statement of objections.
Yes.
A confirmation deed came to be executed by the society, recognizing respondent number 2 as the owner in respect of the sites which came to be renumbered. 250J15 and 250J16 became 3766 and 3767.
Yes.
In this, my title as the GPA holder and then the sale deed in my favor is recognized. I am recognized as the owner, and a supplementary or a confirmation deed is executed by the society in my favor.
Yes.
Therefore, in this manner, I became an owner even in the eyes of the society.
Yes.
Now, kindly see page 20.
No, what is this? It's a vacant site or this thing?
My lord, I had a tenant. As soon as they filed the suit, they came there, they sent away the tenant. On the gate, they have written that this property is subject matter of litigation. Contact person, they put the phone number of the son of the respondent, appellant, Manoj. Manoj, the whole idea of the appellants is this. At a time when they...
Now we have constructed that building there.
I have put up a shed over there. I had a tenant.
Yes.
Now I've given a gift to my daughters.
Yes.
So that they can earn some money from that by giving it on rent.
Yes.
If status quo order is given...
No, that you can do it. Yes. We are not saying that...
Contempt
No, that, now I am modifying that order. No, I am disposing that.
My lord, rightly so, the trial court had come to the conclusion that they are not entitled to any interim protection. Assuming for a moment they succeed in the suit, they can always, first of all, there is no relief to recover possession. They have only filed for declaration that the sale deed is void.
No, see, now that,
Assuming the sale deed is
now
void,
that
they'll have
I
to
will
recover
dispose
possession.
of this, I will dispose of this, directing the trial court to dispose. See, whatever that order passed by the trial court will be confirmed. I will direct him to dispose. Till then, your daughter cannot create further alienation. There is already an alienation to your daughter. There should not be any further alienation, but you can given a rent tenant, whatever that earlier is.
That if your lordships can clarify.
Yes, that I will modify that order passed by the trial court, saying that that second defendant cannot be created, not to further alienation.
Very
till the disposal. Yes, thanks.
One submission. As per the said is 2004 reads, please assumption.
No,
If they-
don't ask any finding from this court. It will adverse you during the trial. Therefore,
no adverse.
no, if I given a finding that in the GPA you have given an absolute right and all, it will affect your right in the trial court. Keep it that for a declaration you prove that there is no absolute right has been given to that defendant number one. Then you can succeed. Or you say that you have not received any consideration and all. It is all subject to the trial.
Yes.
Won't invite any finding from this court. It may adversely affect you. Yes.
One small submission. If the vendors of the property present at the time of the execution of the sale deed, what is the necessity? He can made as a vendor. He can execute the sale deed. In the last page, as
that is
shown
all-
as signatory, as shown as a signatory.
That has to be proved whether
Yes,
it is
please.
true or
Please.
not.
Please.
You might have been taken that money and given a GPA for that better security. They may also taken your signature. That is all there. You need not again execute it in a sale deed. They may say that you also become a witness tomorrow. You may not see this.
Their
That's all.
consideration, I have disputed, that is the
Yes,
the trial of the.
Yes, that's.
My lords, the other aspect is without being signatories to the sale deed, they should have paid court fees on the market value. They have not paid court fees on the.
That
market
issue is
value.
already
That of
decided.
course have been,
Yes,
taken
I am not
as a
deciding
legal-
all this.
That issue is already decided in 711 of
Yes,
I have anyway filed an application to treat it as a preliminary issue.
That's the trial court. I am not touching all this issue. It is only under Order 39 Rule 1 application. Yes. This appeal is filed by plaintiff under Order 43 Rule R of CPC, challenging order dated 4th August 2023, passed by 10th Additional City Civil and Session Judge, Bangalore, OS number 1704 of 2020. Hereby, IA number 3 filed by the plaintiff under Order 39 Rule 1 and 2 has been dismissed. Plaintiff has filed two for declaration and injunction on service of summons along with that plaintiff has filed IA number 3 under Order 39 Rule 1 and 2. After service of summons, defendant appear through their counsel, has filed their objection. After hearing the parties, trial court has dismissed that IA number 3 filed by the plaintiff, being approved by the same. The plaintiff has filed this appeal. What is the stage in that suit now?
It's for evidence. They are not stepping into the box. Several deals,
Yes.
they are just delaying.
Yes. Now I'll fix the time limit.
Very
Yes. Yes. So and so learned counsel appearing for the plaintiff has contended that the plaintiff is in the possession of the suit scheduled property. They are the absolute owner. The defendant have no right or title over the property or try to interfere. into that suit scheduled property. Counsel for the defendant has contended that the plaintiff has executed an GPA in favor of the defendant number 1 for alienation and receiving the consideration amount. Accordingly, first defendant has alienated that property in favor of second defendant, and they are in the possession of the property. And respect of execution of GPA, the plaintiff has not disputed. Further contended that even for the sale deed, the plaintiff has signed that as a witness. Therefore, they have no right or title to the suit scheduled property. Now that suit is be that as it may, now the suit is set down for evidence. Under these circumstances, the only relief can be granted is the order passed by the trial court on IA number 3, dated 4th August 2023, is upheld, subject to modification that the defendant number 3 and defendant number 2 is directed not to alienate that property till the disposal of the suit. The trial court is directed to dispose of the suit as expeditiously as possible, not later than 8 months from date of receipt of copy of this order. Both the parties are directed to cooperate for early disposal. Yes. I have not expressed anything because it will not affect that both the parties.
Manoj, sir also filed an application for contempt, Manoj.
That now that
Manoj, that can still be referred for inquiry, Manoj, even though this has been disposed. That your lordships may still pass an order referring it for inquiry.
No,
If they come to the conclusion that there is no contempt, very well, but the fact is they have committed contempt.
no, in respect of contention raised by that respondent defendant that plaintiff has violated that court order, liberty is reserved to the defendant to file such an application before the trial court.
Manoj, I've already filed it, Manoj. So
Before the trial court.
Before this honorable court, the trial court may not be able to go into violation of an order by this honorable court. Your lordship may refer it to the registrar. That can go on as a parallel proceeding.
Now
If they file objections,
now that in the photos, there the plaintiffs are senior citizens, 69 years, 65 years. In the photos, they are not appearing in the photos.
Now
Their allegation is
now that anyhow that nobody is doing anything, let the suit itself be disposed of.
their contention
Don't
is
pursue all these things. If he any do it, then it is violation of the court because
Yes.
there is no injunction order. Now there is no injunction order. Only that restriction is that you should not create any third party interest.
Yes,
If he
yes.
put up any construction, now that it is in violation, you take an
Yes.
action before the trial court.
very well.
Was
Manoj,
there-
I've already made a application. before the
There,
trial court.
one submission. Another appeal, 5713/23, connected appeal.
ಅದೇನಕ್ಕೆ ಅದು?
ಅದು not to alienation, separate 2 IS matter, IA number 3 and IA number
ಕ್ಲಬ್ ಮಾಡಿ dispose
ಅಲ್ಲ,
of.
ಅದಕ್ಕೆ
Yes, both club together. Yes.
please.
All pending applications are disposed of. 54.1 ಅಲ್ಲಿ you take
I
notice.
take notice, I'll file a complaint.
Yes. So and so is undertake to appear for respondent. Yes.
And we wait for the appellant. See, the appeal filed by the owner of the vehicle minor. This matter is fully covered by the judgment of this honorable.
Why that liability has been fixed on the owner?
But kindly say, as on the date of accident, the permit was on lapsed condition and subsequently it has been renewed. This point is fully covered by the judgment of this honorable court. wherein where the Honorable Court clearly held that in view of section 8A subclause 5 of the Motor Vehicles Act, the renewal, effect of renewal come back to the date of expiry. Similar matter, kindly see.
No, that you have to submit an application within that limitation.
There is some delay is there, but my lord, in the vehicle was fully covered with insurance, and we are not contesting the matter. Only after filing the execution by the insurance company.
See, your case is that permit is expired.
Yes.
If the permit is expired, you have to file an application for renewal within that limitation.
Yes, that is done.
That was done. Then only it will coming back to that the date of expiry.
Yes, madam.
Otherwise, it is a fresh license.
Yes, madam. Also, kindly see, the date of accident is 5/2/2018.
5/2/2018.
Permit expired on 13/12/2017. Permit expired on 13/12/2017. Then permit renewed on 7/2/2018.
Then you have filed an application for renewal.
You know, that is not the question involved in this judgment. The renewal itself come to the date of expiry. So you
can file an application for renewal after 10 years. That is not that law. You see that somewhere that limitation is there. No, if you see, nobody will renew. After that accident of 5 years, they will file an application for renewal. That is not that. Because if you filed within that limitation, it will be go back to that earlier date. Otherwise, it is in a fresh.
No. That's the kindly section 88 subclause 5, madam.
Where is this? What is this code said?
88 subclause 5 of the. May I rely upon the judgment of the minor act, madam?
The act first. We'll see that.
Section 88 subclause 5 clearly says. Motor vehicle. 19. 88 subclause 5.
88. What do you want? Read.
88 subclause 5. Kindly, sorry. Section 81, madam. 80. Section 81, duration and renewal of permits. Then subclause 5, where a permit has been renewed under this section, after expiry of the period thereof, such renewal shall have effect from the date of such expiry. ಯಾವುದೇನು ಅಪ್ಲಿಕೇಶನ್ ಮಾಡ್ಬೇಕಂತ
ರೂಲ್ ಇರುತ್ತೆ ರವಿ. ಹಂಗಿಲ್ದೇ ಇದ್ರೆ 10 ವರ್ಷ ಬಿಟ್ಬಿಟ್ಟು ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ ಹಿಂದಿನ ದಿನದ that cannot be somewhere without the payment of the tax. There is a rule that will change when that where is this, what is this judgment?
Because kindly see the judgment, my lord.
ಇಲ್ಲಿ ಏನಾಗಿದೆ, what is the facts?
Oh, my lord, fact of the case is, my lord, para number 3. Para number 3. In the claim petition laid by the dependents of the deceased, the insurer of the operating vehicle took a specific defense that since on the date of accident, the fitness certificate and the permit were not enforced, it was not liable to be indemnified the liability of the owner, although the insurance policy was enforced. This is the case of the party. Then the findings of this honorable court. Para number 12, my. Para number 12 judgment. A coordinate bench of this court had an occasion to
ನೋಡ್ರಿ,
examine-
para 11 ಓದ್ರಿ. Para 11 ಓದ್ರಿ.
For renewal of permit, an application should be filed not less than 15 days before the date of expiry of the permit in accordance with the subsection 2. Subsection 3 clearly states that if an application cannot be made within 15 days before expiry, the regional transport authority or the state transport authority can still entertain an application for renewal of a permit if it is satisfied that the applicant was prevented by good and sufficient cause for making an application within the time specified. That means if sufficient cause is shown, application can be entertained and permit can be renewed. If permit is renewed,
upon application made before expiry, automatically the renewal takes place from the date of expiry. It's a discretionary power of the transfer. Then, whenever the renewal is sought after expiry of the time, if the concerned authority entertains such an application according to section 81(3) and grants renewal by condoning delay. Now, obviously, the renewal goes back to the date of expiry, as provided under section 81(5) of the Motor Vehicles Act. Temporary permit is issued for the interim period, and it has nothing to do with the renewal. Then paragraph 12. A coordinate bench of this court, an occasion to examine a similar issue in the case of United India Insurance Company Limited versus Yasmin Begum Supra, what is said as merit. On a reading of the opposite provision, it becomes clear when the permit is issued in the first instance, it is effective from the date of issuance for a period of 5 years. But subsequently, when permit which has expired is renewed, it is from the date of expiry. Having regard to subsection 2 and 3 of section 81 of the Act, where there could be a delay in making of an application for renewal of permit, and also keeping in mind the fact that renewal application would take sometimes for it to be considered, processed, and ultimately the permit being renewed. Even though such an application has been made well within time, subsection 5 of section 81 of that takes care of a period during which the vehicle is playing on the public road. Pending renewal of the permit, in such case, subsection 5 of section 81 of the Act states that where a permit is renewed after expiry of its period, such a renewal shall have an effect from the date of such expiry. In other words, such subsection 5 of section 81 of the Act deals with a case deemed permit or takes care of a situation where pending renewal of a permit. A transport vehicle is playing on a public road. In such situation, it cannot be considered to be a case where the transport vehicle is playing without a permit. Rather, the vehicle is playing pending renewal of the permit, that is on a deemed permit. Renewal of the permit could take place only if a permit had been issued in the first instance and not otherwise. Hence, the object of a provision incorporating a legal fiction must be given its fullest scope and application.
Only in respect of that, if you file the application within the time.
Yes. We have made within the time. Even though the transport authority has a discretionary power, even though there is some delay, the transport authority has some discretion to condone the delay. Once the permit is renewed, my lord, the effect would be from the date of expiry.
Where is the renewal of the permit? Renewal of the permit from that expiry period, or it has been renewed from the date it has been
from the date of expiry.
And the renewal.
Lots of kind additional document I produced.
The support of this code is not an applicable because of
My lord, page number 69. Page number 69 of that. Illodi, date of expiry permit 4-12-2012 to 3-12-2017 17ಕ್ಕೆ ರೌಂಡ್ ಅಪ್ ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲಿಂದ 22 ಬಂತು.
Where is that? Where are you relying on? What is that?
My lord, is page number 69. Additional document. Along with IA number. Page number 69. Point number 4, my lord. Date of expiry of permit 4-12-2012 to 3-12-2017 17ಕ್ಕೆ ರೌಂಡ್ ಅಪ್ ಮಾಡಿ 2022 ಮಾಡಿದ್ರು. ಅಂದ್ರೆ it continues from the 4-12-2022 continue ಆಗಿರುತ್ತೆ.
Where is that issuing date, Mr.? It is 2012, right?
ಹೌದು, 2012ರಿಂದ 17ವರೆಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಮೇಲೆ 17ರಿಂದ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗಿ 22ವರೆಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲ ಐತ್ರಿ 22ರಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡಿರೋದು ಎಲ್ಲ ಐತ್ರಿ?
ಇಲ್ಲೇ ಕೆಲಸ ಪೇಜ್ ನಂಬರ್ 69 ಅಲ್ಲಿ
22 ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಎಲ್ಲ ಐತೆ, ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ, ಏನಿಲ್ಲ. ನೀವು ಯಾಕೆ ಇದನ್ನ 28 ಮಾಡ್ಕೋಬಾರ್ದು? ನೆಕ್ಸ್ಟ್ it has to be issued by separate this thing. ನೀವೇ ಡೇಟ್ ಬರ್ದಿರಂಗಿದೆ.
No.
ಆಯ್ತ್ರಿ ಹೆಂಗ್ರಿ 2012 ಅಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡಿರೋದಕ್ಕೆ can they say 2022? What is that meaning that the signing on 2012?
But kindly see the data order passed by the trial court.
ಎಲ್ಲೈತ್ರಿ ಆರ್ಡರ್ ನಿಮಗೆ? ಇಸ್ ದೇರ್ ಎನಿ ಸಪರೇಟ್ ಆರ್ಡರ್ ದಟ್ 2022 ರಿನ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಅಂತ?
ಇದ್ರಲ್ಲೇ ಮಾಡ್ಕೊಡ್ತೀವಿ, ಸಪರೇಟ್ ಆರ್ಡರ್ ಇತ್ತು ನಾಟ್ ವೆರಿಫೈಡ್.
ಅಂದ್ರೆ ಇದರಲ್ಲಿ
kindly see the findings of the trial court.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಫೈಂಡಿಂಗ್ ಬಿಡಿ, see this is records ಸರ್.
ಇದ್ರೆ ಅವ್ರ ಪ್ರಕಾರ ಇದನ್ನೇ ಆಗಿದೆ ಅಂತ ಆಗ್ತದೆ.
ಅವ್ರು ಬಿಡಿ, ಅವ್ರು ಏನ್ ಬರೀತಾರೆ, now you have to convince me how that authority which has signed in the 2012 saying that it is 2022.
Kindly see first page, madam, page number 68. ರೀಸೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ವ್ಯಾಲಿಡಿಟಿ ಫ್ರಮ್ 27 ಜನವರಿ 2023
ಅಲ್ಲಿಗೆ ಇದು ಹೊಸದಾಗದಂಗ ಆಯ್ತು. ರಿನ್ಯೂವಲ್ ಅಲ್ಲ, ಇಟ್ ಇಸ್
ನೀವು ಅದೇ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಹೆಂಗಾಗುತ್ತೆ? ಲಾ ಸೇಸ್ ದೇ ಹ್ಯಾವ್ ಟು ಕಂಡೋನ್ ದ ಡಿಲೇ ಅಂಡ್ ಸೇ ಅದರ್ವೈಸ್ ಇಟ್ ಇಸ್ ರಿನ್ಯೂವಲ್. ನಿಮ್ ಪ್ರಕಾರ ತಗೊಂಡೋದ್ರೆ 10 ವರ್ಷ ಬಿಟ್ಬಿಟ್ಟು ಆಮೇಲೆ ರಿನ್ಯೂವಲ್ ಮಾಡಿಸ್ಕೊಂಡ್ಬಿಟ್ಟು ಇಟ್ಸ್ ಕವರ್ ಟು ದಟ್. ದಟ್ ಇಸ್ ನಾಟ್ ದಟ್ ಮಿಸ್ಟರ್. ಹೌ ಕ್ಯಾನ್ ದಟ್ ಮಿಸ್ಟರ್?
That is not point is, my lord. Case is very clear, my lord. As on the date of accident, the permit was renewed, lapse condition. Subsequently
renewed from subsequent date. Subsequent date is renewed adre, it is not that from the date it has been expired.
Alige barutte. Is the view of the court.
No, mister. That is wrong. No, that is the different case. In your case, it has been renewed from 2023.
Annalla. You not kindly see that.
Yes, that is your argument. I consider.
Page number 69 agide. And then the problem ಏನಾಗಿದೆ ಅಂದ್ರೆ already when there is settled proposition under law, ಮೊನ್ನೆ recent of my lord not Krishna Kumar has taken the very same view in the third bench.
There is no dispute at all, mister. In your case, where is that condoning the delay and renewing from the date of expiry?
Such is the case, then I will apply the right information from the authority. In the meantime, my difficulty is I already filed an execution petition and the recorded proceeding is going against me. Issue was directed to recover the amount from me. That means
yes, that you have to pay what that claimant will do. If you succeed, you can recover.
It's something difficult. Something difficult for the owner of the vehicle because the law is in his favor.
Where is that law is in favor, mister? This is your argument. I will pass an order now. You take it to the Supreme Court. Which is that law in favor? Can you say that 2012 signature it is for the 2022?
To that effect, my lord, I will collect the document before this honor.
You produce it.
Again, document or incorrect ಆಗಿರಬಹುದು. Then I will apply it.
You produce. There will be an order for condonation of delay, and you say that yes, he is entitled for that. There will be an order. You produce it. Then we'll see.
Interim, the procedure kind of stay.
50% deposit. No, mister. You taking that vehicle and kill that person's life.
When the amount is already paid, my lord, insurance company has already paid the amount to the claimant. After that, my lord, insurance company has filed a
insurance company has recovered. You have paid that.
Yes.
Where is that order for this thing by that insurance company? Where is that recovery proceedings?
My lord, first document. Page number 61, my lord.
Have they filed any objection to that IA for condonation of delay?
No, they are not.
Heard that learned counsel for the appellant. Respondent has not filed any application for objection for condonation of delay. Peruse that affidavit for the reason stated in that accompanying affidavit. Delay of 389 days in filing an appeal is controlled. IA 1 of 2023 is allowed. Yes, what is that stay you are seeking?
Further proceedings of execution.
Execution.
IA number 3, my
our execution now that they are pursuing by that insurance company and
yes. Our insurance company has paid the amount to the claimant. Then insurance company has initiated proceeding against me. My lord, IA number 3 ಅಲ್ಲಿ IA number 2
I want to confirm that whether amount has been reached to that claimants or not.
It's already paid, me. My lord, page number 61. Yes. Execution petition number 30 bar 2023.
30 ಅಲ್ಲಿ MEC ಏನು ಪೇಂಟ್ ರಿಕವರಿ ಮಾಡಿದಾರ?
ಅಮೌಂಟ್ ಕಟ್ಟಿದ್ದಾರೆ. ನಮ್ಮ ಹತ್ರ ರಿಕವರಿ ಹಾಕಿದೆ.
ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ execution. What is that number? Execution number 30 of 2023. Heading in the file of senior civil judge Kundapura till next date of hearing. In the meantime, you produce and
Please, madam, please.
May I request, my lord? I request, my lord.
59, my lords. My lords, one matter was listed yesterday, 3830. Lords, it is listed on Monday. My lords, it may be tagged along with that. My lords, the batch matters are listed on
yes,
Monday.
use this matter on Monday. Yes. On
Along
that day we will connect. Yes, we will connect that.
ಅದು ಬಂದಿದೆ. My lords, yesterday one matter was listed. I given that numbers. I given
Use this learned counsel for the appellant submit that this appeal may be called along with its own.
Yes.
Serial number 57 appearing for appellant. Week accommodation.
Yes, at the request of counsel for the appellant, leave this matter next week.
Serial number 60, they have taken time. My lords. 8-page fixed, my lords, urgency, my lords. Now they have taken, my lords, there was an order of not to alienate and not to interfere with my possession. My lords, your lordships has expressed that regarding status quo has been granted. I'll subject to hearing this matter today, my lord. Lords, morning they have moved the
Who has
matter.
taken the time?
ಮತ್ತೆ GS ವೆಂಕಟೇಶ್ವರ
Connected matter ಇದೆಯಾ?
ಹೌದು. 4 ಇದೆ.
next week interim order granted
Next week ಅಂತಂದ್ರೆ next Thursday.
Yes.
Next Thursday.
May I submit, my lord?
Yes.
My lord, my apologies, my lord. Serial number 24, my lord. I will take fresh address steps, my lord, to the respondent number 1 and 2, my lord.
24 ಬ್ರಾಂಚ್ ಅವ್ರು ಕರ್ಸಿದ್ರು. ಇವ್ರು ತೋರಿಸಿರೋದು ರಿಟರ್ನ್ ಟು ಸೆಂಡರ್ ಅಂತ ನಮ್ಗೆ ವಾಪಸ್ ಆಗಿರೋದು. ಇಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ವಾಪಸ್ ನಮ್ಗೆ ಬಂದಿದೆ. ಎಲ್ಲ ಇಲ್ಲೇ ಇದೆ. ರಿಟರ್ನ್ ಟು ಸೆಂಡರ್ ಅವರು ಐಟಮ್ ಡೆಲಿವರ್ಡ್ ಅಂತ ಏನಿದೆ ರಿಟರ್ನ್ ಟು ಸೆಂಡರ್.
That is my apologies, my lord. Item delivered to the sender antide, my lord. The address I will furnish a fresh address, my lord. I will furnish fresh address, my lord. Respond number 1 and 2, my lord.
ಅಷ್ಟೇ ಮಾಡೋದು. ಆಕ್ಷನ್ ಎಲ್ಲ ಏನು
One week.
Acknowledgement which I filed, my lord. Acknowledgement duly served to the trial court advocate, my lord.
No, that is not the service.
I will take fresh steps, my lord. Fresh address, my lord.
Yes.
Grateful, my lord. Great.
Court officer. Court officer.
ಒಂದು ನಿಮಿಷ ಮೇಡಮ್, ಒಂದೇ ಒಂದು ನಿಮಿಷ. 59 ಮಂಡೇಗೆ 57 ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Court officer.
ಒಂದು ನಿಮಿಷ ಮೇಡಮ್, ಒಂದು ನಿಮಿಷ.
Serial number 65 ಏನಾದ್ರು ರಿಟರ್ನ್ ಆಗಿದೆ ಸರ್?
ಹೇಳಿ ಮೇಡಮ್.
65
ಅವ್ರು ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರು ಮೇಡಮ್ ಬೆಳಗ್ಗೆ.
ವಿಡ್ರಾ ಮಾಡಿದ್ರಾ?
ಹಾ.
65
ವರ್ಧಮಾನ್ ಗುಂಜಾರ್
ಓಕೆ
ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರು.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಏನೂ ಇಲ್ಲ, ಬರೀ ಒಂದು
What are they? 25 lakhs for the. That's why I asked him and I have been waiting for that case. ಈಗ ಅದು ಇದೆ ಈಗ ಟ್ರೈಕೋಟ್ ಆರ್ಡರ್ already abroad, right? So what we have to do in the can say that again we refer that to have making. Yeah, no, something informal. No, nothing about it. Whether they file a memo, they mention we would be waiting there. They're not asking when they want to happen. But they would have gone there also means imagine.
Hello, court officer. Court officer. Court officer. Hello, court officer.
ಜಾಯಿನ್ ಆಗ್ಬೇಕು. ಲಾಗೌಟ್ ಆಗಬೇಕಿದೆ ಕರೆಕ್ಟ್ ಆಗಿ ನೋಡ್ಕೊಂಡು ಲೀವ್ ಅಂತ ಐತಲ್ಲ ಇಲ್ಲಿ ನೋಡೋದು
ಶುಗರ್ ಫ್ರೀ ಇರುತ್ತೆ ಅಥವಾ
Number 61, Telecast review for appellant, Interim Gouda. Number 61.
I appeal for the respondent first. 61, my lord.
Respondent. Yes, they are not there. None appear for the appellant. This is matter of 2 weeks.
Number 62.
They go on bank, they was given a letter that should not operate. And they represent that appeal is pending, don't operate. We have to give salaries. Well, I'm telling, but stay is vacated in the court below. They go on telling before the bank, so the appeal is pending, don't give. There
No,
is
that
no-
you say that they are not prosecuting that appeal. Pendency of the appeal will not come.
Yes, madam, I will do.
Number 62, we are asking for the review for appellant.
That's one. Put for partition filed by the first respondent. It's the appellant another. Done with the partition, for partition.
You are a plaintiff or a defendant?
I am the second defendant.
Second defendant.
Among the relationship is admitted, but the contention of the defendant is that between the three brothers, there was a partition in the year 1989. Since then, they are separately living and there is no joint family nucleus. That was the main contentions. And as per the partition, the invitation and the antecedents, everything is separately done and they are exclusively the question. Under the said partition, the second defendant was given item number 1, survey number 160 or 19. It measures about 1 acre that. And he, second defendant, transferred before filing of the suit, it has been gifted to his wife, Srimati Sharala. Sharala took the loan about 4-5 lakhs, and she has established the grape garden with a fencing, all that. So now the plaintiff filed a suit along with 2 IACs filed. One is not to alienate suitable properties, I1, and IA5 not to restrain him in passing through survey number 160/1 to his property 160/4. Both the IAS has been clubbed together. Common order has passed through both the IAS is allowed. As far as the not to alienate the IA number is concerned, I am not pressing for that. But IA number 5 is coming. The advertisement is IA number 5. They want to make a 8 feet with road demolishing this grape garden structure, the plants and also the fencing.
In which property?
That is item number 1. It is my property.
Item number 1.
Item number 1.
Where is
How he wanted to go to item number 1 to the survey number 160/4 sub number. But that is not
an agent, servant, anybody claiming through them are hereby restrained from alienating the suitable property. Item number 39. About the defendant and anybody claiming through him are hereby restrained from stopping the plaintiff from making use of the 8 feet road as to reach other suit property. That survey number 160/1 is belongs to you.
160/1 belongs to me. In fact, it is in the name of my wife. But my wife has not been made as a party. The second defendant has been made as a party. But they are not restricting. The people in the budgets go around in the village. There is no existing road, recognized road, path like 8 feet in the village map, but people used to go to the surrounding survey numbers. We can also go to this number, and also on the other side also has got. Our people are not restricting. You can go on, but several people will be using this land, but just in the center. So because there will be width for each plantation, so they are moving it. We are not objecting you to move on that, but taking it, you want to decide. Using this order, demolish and plantation one side 8 feet width to form a road.
So him hereby restrained from plaintiff from making use of that 8 feet existing. No, they are not allowed to make in a road. They can use it. That's all. You can't.
Order is like that. Appliances now they are bent upon to make a road, demolish this one side.
That is an, you can file in a contempt if they are violated. Why do you are filing an appeal?
Submission matter. See, this is the lady. With the help of police, they want to pressurizing them to allow them to go to 8 feet.
You have to convince
Let
the
them,
police.
let there be a stay. Let there be an order of status. But I can be say they should not damage this. Your honors can modify stating that they should not demolish or make
Issue notice. Parties are directed to maintain status quo in respect of survey number 161/1.
Item number 1.
Where is that description of the property? Where it is situated and all? 160/1. Measuring 1 acre 5 guntas. Situated in Srirampura village, Nandi Hobli, Chikbalapura Taluk, in next state of Hiri. Yes. Yes. 2 weeks it has been urgent. No, 6th, 7th I have given day. We'll 13th, 14th are long holiday. 15th. 8th is that the motor vehicles matter as there. Then from 11th, 12th, 13th, 14th is on holiday. Only 15th. 15th. Then so 7th, 8th. See, now I have taken 2 days for motor vehicles because motor vehicles all subjects has been this thing. We can take chance on 9th. 9th. This matter 9th. Yes. Yes.
First or matter, serial number 45, Naradamba AR for appellant. Serial number 45, Naradamba AR.
Pass out.
Regularly matter, serial number 64, Nathan B for appellant. Connected matter, will be argued.
For the appellant in this case.
Last time ನಾನೇ ಟ್ರೈನ್ ತಗೊಂಡಿದ್ದೆ.
What is that issue involved?
Issue is not, he was claim is that he was working in the CRPF. Pursuant to the accident, then speech loss ಆಗ್ಬಿಟ್ಟು unfit for duty ಅಂತ ತೆಗೆದುಬಿಟ್ಟಿದ್ದಾರೆ. So their claim is since he is not fit for duty as a consequence of this injury, I would be entitled to 100% disablement ಅಂತ.
ಯಾಕಂದ್ರೆ ಕೆಲಸ ಹೋದ್ರೆ ಸಂಬಳ ಪೂರ್ತಿ ಕೊಡ್ಬೇಕು.
ಸಂಬಳ ಪೂರ್ತಿ ಕೊಡ್ಬೇಕು. ಕಂಪನಿ ಒಂದು ಲೆಟರ್ ಹಾಕಿದ್ದೀನಿ, ಅದೇನೋ ಕಮ್ಯುನಿಕೇಶನ್ ನನ್ನ ಕಡೆ ಮಿಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಅಲ್ಲ ಏನು, ವಾಟ್ ಇಸ್ ದಟ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಯು ವಾಂಟ್ ಟು ಗೆಟ್ ಇಟ್ ನೌ?
Information I want to tell them that this is a case fit for settlement. ಏನೋ ಆದ್ರೆ ಆಗ ಇಲ್ದಿದ್ರೆ
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಕೆಳಗಡೆ ಕೊಟ್ಟು?
15,70,000 is about.
ಡಿಸಬಿಲಿಟಿ ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲಿ?
ಅಲ್ಲಿ 50%.
50% ಮಾಡಿದಾರ. ಇನ್ಕಮ್ ಎಲ್ಲ ತಗೊಂಡಿದ್ದಾರೆ.
Income ತಗೊಂಡಿದ್ದಾರೆ, but not the future prospects add ಆಗ್ಬೇಕು. Since 100% future loss of income is there, but even
regarding legal issue now, I am the court pleaser. I might not lie in my mouth to say so, but we give him 100% plus the future prospects. The multiplier aspect should be slightly reduced, applying the principle
that split multiplier Supreme Court.
Split multiplier, the multiplicand will become very large because we will now be taking the entire salary plus we will be taking 50%.
No, I think 100%. What is that? This thing injury. Is there any
disability? ಮಾತಾಡೋದಕ್ಕೆ
speech disability.
No, he may lost the job.
He has lost.
He may work for other and he can earn, it cannot be 100%.
That is
100, see 100% ಅಂತಂದ್ರೆ he can't do any work. ಈಗ ನಿಮಗೆ ಕೆಲಸದಿಂದ ತೆಗೆದಾಕಿರೋದ್ರಿಂದ can be 75%. He can do other work and earn that other 75% from that.
he is unable to do his military service. As a man, the principle of dignity of labor.
He can do other work also. If there is any such judgment saying that if he removed from the salary, he has to give 100%, even though he is fit for doing other work.
No doubt, my lord, he can do some other work. Not that cannot be considered, my lord, for deducting any loss of future income. That ratio is being laid down by this honorable court.
Really there. ಈಗ ಇಲ್ಲಿ ತೆಗ್ದಾಕದ್ಮೇಲೆ ಇವ್ ಹೋಗ್ಬಿಟ್ಟು ಯಾವ್ದೋ ಒಂದು ಸೆಕ್ಯೂರಿಟಿ ಆಫೀಸ್ ಇದಾಗ್ತಾನೆ who will give that this thing?
ಅಲ್ಲ ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಡ್ವಾಂಟೇಜಸ್ ಗಳನ್ನ ತಗೋಬಾರ್ದು. ಪ್ಯಾರಾಗ್ರಾಫ್ 41 ಅಲ್ಲಿ just read the entire paragraph itself. But it is said that the applicant is only SSLC and does not possess any skill or expertise, experience or training to undertake any other work, manual or otherwise. After SSLC, the appellant joined the CRPF. Idrallo ee case allo same as a police constable, and he was trained as combating and to perform other duties and function attached to the post of police constable. Since the appellant lacks skills or training or experience to undertake any other work, it is highly improbable and unlikely that the appellant will be able to secure any job, even assuming, despite the injury sustained by him, he is able to perform some light manual work or ordinary clerical work by squatting on the floor with pain or discomfort. Further, it need to be emphasized that it is not the right for the tortfeasor or the person who has taken over the liability of the tortfeasor in terms of and under the act to dictate that the injured person should do some other work or manual work or otherwise. But this is the observation. It does not matter. Maybe with pain or discomfort in or otherwise. It does not matter. Maybe with pain or discomfort. In order to minimize his or its liability, such instances is untenable in law. And if such is the case, it would violate basic human right of the injured person. In this case, the appellant is reduced to such a state that he is unable to do any other work, manual or otherwise, without subjecting himself to pain and suffering, agony or discomfort. In an accident, if a man is disabled for a work which he was doing before the accident, that he has no talent, skill, experience or otherwise of anything else, and he is unable to find any work, manual or clerical, such a man for all practical purpose has lost all earning capacity he possessed before, and he is required to be compensated on the basis of total loss.
ಇಲ್ಲಿ ಅವನು ಬೇರೆ ವರ್ಕ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ, ಡಿಸ್ಕಂಫರ್ಟ್ ಎಲ್ಲ ಇದ್ದಾಗ ಮಾತ್ರ ಅಂತ ಹೇಳ್ತಾರೆ. See here, if he is unable to, if he has do some other work also, he will suffer pain.
Yes,
if that is the case, that is that such an injury he has suffered. Here, ಆತರ ಇಲ್ಲಿ ಏನು injury
shortening of
violating, the appellant is reduced to such a state that he is unable to do any work. He can't do any other work also. Therefore, he is entitled 100%. But here he can do other work also. Then he is not entitled 100%. Where is that judgment? 75% to future prospects ಕೊಟ್ರೆ ಮುಗ್ದೈತಲ್ಲ, ಎಷ್ಟಾಯ್ತಲ್ಲ?
Request at least not 85%.
75%
speech disability ಮಾತ್ರ ಆಗಿರುತ್ತೆ.
future prospects ಬೇರೆ ಸಿಗುತ್ತೆ ನಿಮಗೆ.
ಹೌದು,
ಮತ್ತೆ
it will be added.
ಆಮೇಲೆ ನಿಮ್ದು ಸ್ಯಾಲರಿ ಎಷ್ಟಿದೆಯೋ ಅಷ್ಟೇ ಇನ್ಕಮ್ ಬರುತ್ತೆ, ಅದ್ರಲ್ಲೇ ಇದೇನ್ ಬರಲ್ಲ.
Not at least 80% may not.
75% is enough. You calculate what will be the difference. History. ಅಲ್ಲ, what is that monthly income?
Lord, the monthly income, my lord, is 13,606.
13,306.
306.
13,306 into 17 multiplier 75. ಅಲ್ಲ ಅದಕ್ಕೆ
ಅಲ್ಲ,
what is his
50%.
age? 30 years.
30 years.
25%.
40.
30, 40.
Sorry, my lord, 50%. He's a permanent employee.
A permanent employee, 50%, yes.
3,959 multiplied, sir.
17.
Disability, sir.
75%.
30 lakhs 53,727.
Double the amount. 15 ಲಕ್ಷ ಇದ್ದಿದ್ದು 30 ಲಕ್ಷ ಆಗುತ್ತೆ. 30 ಲಕ್ಷ.
And my lord,
Bank interest, he'll be getting his salary.
and,
That also, if not principle of damages, actually it should get expended by the time I die. That is the general principle. ಈಗ ಅದು ಉಳ್ಕೊಂತದೆ, ಪೂರ್ತಿ ಬರುತ್ತೆ. Interest ಬರುತ್ತೆ. He can also do something else. Therefore, it is a reasonable.
75% ಅವನು ಇದ್ರಲ್ಲಿ ಏನಾಯ್ತು ಕೈ ಬೇರೆ ಏನು ವರ್ಕ್ ಮಾಡೋದಿಲ್ಲ ಅಂತ ಅಂದಾಗ ದಿಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ಈಸ್ ಇನ್ ಫ್ಯಾಕ್ಟ್ ಇಟ್ ಇಸ್ ಹೆಲ್ಪ್ಫುಲ್ ಫಾರ್ ಹಿಮ್. ಯು ಶೋ ದಟ್ ಈಸ್ ನಾಟ್ ಸ್ಪೀಚ್ಲೆಸ್ ಅಂತಂದ್ರೆ ಅದರ್ ವರ್ಕ್ ಮಾಡಬಹುದು. ದೇ ಆರ್ ಡೂಯಿಂಗ್ ಬೆಟರ್ ವರ್ಕ್ ದೆನ್ ಪರ್ಸನ್ಸ್ ಹೂ ಆರ್ ಸ್ಪೀಕಿಂಗ್. ಯು ನೋ ದಟ್ ಮಾತ್ ಜಾಸ್ತಿ ಆಡಲೇ ಕೆಲಸ ಕೆಡೋದು.
Now, my lord, if he is having speech disability from his birth, my lord, since from his birth, my lord, then they have their own special abilities. But in between, if the person knows that
he is compared to that person who speaks from the beginning, ಆದ್ರೆ ಅವ್ರಿಗೆ ಬರ್ದಿಲ್ದಕ್ಕಿಂತನೂ ಒಳ್ಳೆ ಕೆಲಸ ಮಾಡ್ತಾರೆ. ಇವನಿಗೆ ಹಂಗಾಗಿ 75% ಕೊಟ್ಬಿಟ್ಟು ಇನ್ 25% he can do some other work. ಈಗ ಟೆಲಿಫೋನ್ ಬೂತ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ಬೋದು ಅವನು, ಅಲ್ಲೇ ನಿಮಗೆ ಇದೇನಿಲ್ಲ. ಅಥವಾ ಯಾವ್ದಾರ ಶಾಪ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ಬೋದು, ಟೇಕಿಂಗ್ ಎ ಕ್ಯಾಶ್ ಅಂಡ್ ಆಲ್. ಬೇರೆ ಏನು ವಾಚ್ಮ್ಯಾನ್ ಕೆಲಸಗಳು, so many others work he can do it.
I only one more submission. I would just say that I have supported the judgment.
Yes, sir. That's
very.
Yes, that will. We
so
can do other work also. That's what we are doing.
Lord, and so far as pain and suffering and loss of amenities is concerned, my lord, very meager compensation. 25,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ. Amenities, my lord, at least, my lord, in this case, my lord, at least
future unhappy.
Yes, my lord. And food nourishment, attendance charges, my lord, nothing has been awarded.
No, see,
2008 accident. Only pain and suffering ಅದೇನಿಲ್ಲ. Speech loss ಆಗಿದೆ.
ಏನು ಸರ್ ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಇದ್ದಾರೆ ಏನಾರ?
Yes, my lord, there is an evidence.
Any surgery ಆಗಿದೆಯಾ? ಏನಿಲ್ಲ.
Surgery ಆಗಿದೆ. My lord, he was inpatient. Twice he was inpatient. Head injury ಆಗಿದೆ.
ಅಲ್ಲಿ ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಇದೆ?
Initially, my lord, Sanjay Nimas Hospital, my lord, in 22, 5 days he was inpatient. My lord. to 2008 to 8/3/2008 for almost 15 days. Sorry, 16 days.
My appeal is also there for reduction.
You also filed an appeal.
ಜಾಸ್ತಿ ಅಂತ.
Yes, that will consider. Yes. Thank you. Also, learned counsel appealing for the claimant as contempt back. Due to that accident, claimant has sustained head injury. He has undergone surgery. And he became the doctor the evidence. And he become 100% disability. He has examined the doctor. Doctor ಏನು ಹೇಳಿದ್ದಾರೆ?
Not the speech disability product. Pass on the certificate itself.
Examine the doctor as TW3 na?
3.
The 3. He has deposed that claimant has suffered speech disability to the extent of 93%. due to the disability, that claimant has lost his job. Therefore, as per Exhibit P11, therefore, tribunal has to consider functional disability 100%. The tribunal is error in considering only 50% of disability. He further contended that in view of judgment of apex court in case of also, the claimant is also entitled for future prospects. Secondly, he has contended that due to that extent, claimant has suffered grievous injury. He was inpatient for a period of 16 days. He has undergone surgery and he has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and future unhappiness is on lawyer side. Hence, he sought for enhancement of compensation. P.B. Raju, Learned Counsel, appearing for Insurance company, has contended that the injury suffered by the claimants contended that the claimant has not undergone any amputation of his upper limb or lower limb. He has suffered an head injury. Due to that, doctor has assessed only a speech disability. There is no other physical injury. Therefore, he can do any work. He can do his work. The injury will not come in his actual profession. The tribunal error in assessing whole body disability is 50%. He further contended that have you examined your employer?
Not I have produced the certificate for termination.
Except he further contended that except producing that, what is the certificate
P11.
P11 certificate issued by his employer. He has not examined his employer. Therefore, the tribunal is error in considering the income of the claimant has suffered a loss of income of rupees 13,306 per month. He further contended that he was inpatient only for a period of 16 days. And he has not suffered any physical injury. In other circumstances, the compensation awarded by the tribunal for pain and agony and future unhappiness is also on the higher side. Yet he sought for reduction of compensation. Or the learned counsel for the parties arose judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 21/2/2008 due to rash and negligent driving of rider of motorcycle bearing registration AA 46 E3385. Due to that accident, the claimant has suffered the following injury. Take doctor evidence. The doctor has deposed as follows. ಅದು para 1 ಇದೆ. It is very clear from the evidence of the doctor PW3 and Exhibit P4 wound certificate and Exhibit P8, P9, and P10 certificate issued by Medical Board of Examination. The claimant has suffered speech disability. It is also not in dispute that it is very clear from that Exhibit P11 certificate issued by CRPF the claimant has been removed from the service. Therefore, the disability has to be assessed. So, loss of future disability has to be assessed 75%. All body disabilities has to be assessed 75%. In respect of monthly income is concerned, the claimant has produced salary certificate. Yes. Salary certificate as Exhibit P12. From Exhibit P12, it is very clear that he was getting salary of rupees 13,306 per month. Therefore, monthly income has to be considered as 13,306. In view of judgment of apex court in so and so, the claimant is also entitled for future prospects. In view of judgment of apex court in case of Pranay Sethi, the claimant was aged about 30 years and he was in a permanent employment. The future prospect has to be considered as 50%. The multiplier applicable to this age group is 17. Accordingly, loss of future income has to be reassessed as follows.
13,306 plus 6,653 at the rate of 50%, 19,959. 19,959 into 12 into 17 into 75%. 30 lakhs 23,727.
Due to the tax gain, claimant has suffered the aforesaid injury. He has suffered a head injury. He has undergone surgery. He was inpatient for a period of 16 days. He has suffered a lot of pain during the treatment. He has examined the doctor. Doctor has assessed the disability in respect of assessed the speech disability. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and agony from 25,000 to 60,000. Loss of future unhappiness has to be enhanced from 15,000 to 35,000. Accordingly, the appeals are disposed of. Accordingly, the appeal filed by the claimants allowed in part. The appeal filed by insurance company is dismissed. The judgment and award passed by the trial court is modified as follows. Insurance company is directed to deposit. Dismiss the daily. Amount in deposit is transferred to private. Yes. Yes. Directed transfer, yes.
64 now, second time passport matter.
My lord, serial number 65, my lord.
Yes.
My lord, appear in behalf of the respondent, my lord.
Yes,
65.
who has taken time? No, they have withdrawn this appeal.
Oh, please, my lord. They did not inform me, my lord, that please. No memo is also being served on us, my lord.
No, that in the court hall they have given a memo and withdrawn the appeal.
Please, my lord. Okay.
That's good. Yes, yes. They have filed it in the counter and withdrawn that. Yes.
Please, my lord. Oblige.
Passport matter, serial number 45, Anandama ER for appellate.
Yes, madam.
Appeal to the student, my lord. Appeal for my lord. The findings are appeal. What is good for the henna? What is the trial court, my lord? Look here, the application is we are finding this application for the extension of the time, my lord.
She complied with all the application on certification notes of complaint.
Is my lord.
On the ground again, then granted our London process of but if office objection is not that can be time. But then registry. Cost has been imposed.
Had paid.
Paid.
Had paid.
And then what is that office objection which have to be complied now?
No, now no office objection, my lord. I now the barriering on application IE number 1.
For what extension? What?
For the payment of court fee, my lord. Still the payment has not been paid. Whatever the amount which has been given by the land acquisition officer in after type of decision, still they have not paid the amount and the compensation amount complete. Still, I mean, therefore, I pray the honorable court to kindly extend the time for the payment of the court fees, my lord.
No, how many days, madam? It is
My lord,
2018.
still they have not paid completely, my lord.
That is for you. If you are not paid, you go to the court and get it direction. To pay the...
Execution file ಮಾಡಿದ್ರು ಕೂಡ still out of that 10 lakhs where they had paid only 3 to 4 lakhs, my lord. It's the only the landless corpus, my lord.
What is the court fee you have to be paid here?
87,500.
3 to 4 lakhs you have taken and you have not paid the court fee.
My lord, ಅವರು ಮನೆ ಕಳ್ಕೊಂಡಿದ್ದಾರೆ, ಜಮೀನು ಕಳ್ಕೊಂಡಿದ್ದಾರೆ. ಈಗ
ಆಯ್ತು, ಅದು ಬರುತ್ತಲ್ಲ.
10 ಇಂದ ಕೂಡ ಅವ್ರಿಗೆ ಜೀವನ ಕೂಡ ಮಾಡ್ಲಿಕ್ಕಿದೆ, my lord. ಹಾಗಾಗಿ ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಟ್ಟರೆ ಕಟ್ತೀವಿ, ಅಪೀಲ್.
Yes. The net counsel for the appellant pays further time to comply that office objection. Finally, 4 weeks time is granted to pay the deposit court fee. ಮಾಮೂಲಿ 60 ಅವತ್ತು ಹೇಳಿದ್ರೆ ಬಿಡಿ ಅರ್ಥ ಆಗುತ್ತೆ. ನಾಳೆ ಮಧ್ಯಾಹ್ನದಲ್ಲಿ ಇಲ್ಲ ಅದು ಇದೊಂದು ಚೇಂಬರ್ ಆದ್ರೆ ಪರವಾಗಿಲ್ಲ. Oh.